Hey, how are you doing today? Yesterday, I posted two videos about the just a little like recap for Gabby Petito and Gabby Petito and Brian Laundrie. And I knew there was a live stream trial or pre-trial that was going on, but I didn't want to watch it because honestly, there's a lot of key information that I forgot and I just needed a major recap. So I wanted to do a major recap and I was like, you know what? I might as well make a video of it in case you guys want to recap as well and just be up to date with what's going on with the Petito v. Laundrie lawsuit that's happening. But yeah, let's watch they had a civil lawsuit hearing yesterday, and I know the outcome of what happened, but I want to sit down and I want to listen to it with you guys, and let's do that actually. But I hope you guys are doing well, and hello. Sorry I didn't stream yesterday. I was thinking about streaming, but I was like, you know what? I don't want to listen to this and then be lost in all the facts and stuff. I want to make sure I had like all the major facts out there. What's up, Bleep? How are you doing today? How's it going? This was a pretty extensive, lengthy pre-trial hearing. I think it's like, I think it was like 3 to 4 hours long. So I've already listened to it in like 2 times speed, although I wasn't really like intently listening to it. I want to sit down today and we are going to speed up a little bit, but I do want to be, let's see, I do want to be more focused. Hi, everyone. Hi, Patty. Hi, Brandon. Your wife's finally home. Yay. I hope she's doing okay. Hey, good morning, Dave. What's going on? How are you doing? Hello. All right, we got the lawyers coming in. And again, Brian Laundrie's parents are not in the pretrial stuff. Haven't been seeing them. But I do see Steve Bertolino right there. Did I hear about Brian's? You know what? I did hear about something about a grand jury. Yeah, Brian, but I didn't read the article though. I only saw the thumbnail. I just saw Koberger's parents, something about what's it called, grand jury. But wait, it's about a missing. Did you hear about Brian's parents testified in a grand jury about a murder of a missing 45-year-old woman? No, specifically that. No, I just saw Brian Koberger parents and then grand jury. That's all I heard. I thought it had something to do with his case. I didn't know it was like with someone else's. She's resting right now. Hi, Charles. How are you doing today? Hello from Oklahoma. Out on the gator, but tune in nonetheless. Wait, out on the gator? Where are you at? You out in the swamp area or something like that? All right, guys. So this is a lengthy hearing. But I'm going to go to this part right here. So we're going to start off with, we have Bertolino right there. This is the Laundrie, right? That's how you pronounce your last name. I don't know. I keep mixing it up. Laundrie, whatever. That's their lawyer. And then this is going to be Bertolino's lawyer. And then this, I don't know who she is. Oh, sorry. You guys can't see the screen. My bad. I thought I had the screen up. Right here is Bertolino's lawyer, Laundrie's lawyer. And then that's Bertolino right there. I'm not too sure who she is right there. Maybe another lawyer that Bertolino hired since we're like sitting next to each other and they've been talking. Hi, James. How are you doing today? How's it going? Oh, it has to do with the case. I didn't read the article either, but the lawyer, touched on it. Ah, okay. Gotcha. Yeah, I didn't read it. I haven't taken a look at it yet. So I have no comment on that so far. But yeah, if you guys read it, let me know. Let me know what's in it and I'll read it later on. Do appreciate you sharing it with me. So I had to really boost up the audio for this. I think I did max volume on everything. And then I went on the extension and did like ×3 the gain or something. Let me know if it's too loud. Let me know how it is. I'm going to have subtitles up and we're going to speed it up a little bit. I think we can do 1.5.
Hey, police court. Yes, sir. Judge, once again, Chuck Meltz and Laura Kelly on behalf of Mr. Bertolino. We're here today on the motion to dismiss the Second Amendment complaint as it relates to Mr. Bertolino. Mr. Bertolino, as the court's aware, was added as a defendant in the Second Amendment complaint. The counts against him appear at counts 3 and 6.
Yeah, so initially the Petito Schmidt family, they were going to just sue Brian Laundrie's family. However, a little bit afterwards, they did an amended complaint where they added Steve Bertolino. And Steve Bertolino was previously the Laundrie's lawyer at the time and spokesperson. And he was the one that released the press release stating that, I know you guys are looking for Gabby. I hope you guys find her and I hope she reunites the family. That's just a basic general recap. So now he's added onto the lawsuit as well.
Although the counts are not labeled, it's clear from the history of this case and the nature of the allegations that the counts are premised on intentional infliction of emotional distress. And because of that, they derive from the Restatement of Tort, Section 46, which sets forth the various requirements for that count. Various Florida cases have interpreted that, all of which we'll discuss. Understanding we are here on a motion to dismiss, the way I plan to argue this is really to focus on the Second Amendment complaint, as the court must do. Understand that the court must accept the allegations of the Second Amendment complaint as pled. However, when we go through the Second Amendment complaint, I believe what we're going to be able to show is that those allegations fail as a matter of law and do not establish a cause of action for intentional infliction of emotional distress.
Okay, tell us why.
We will also focus on the purported language that's at issue, Mr. Bertolino's comments as cited within the Second Amendment complaint, which our position, again, is do not support a claim for intentional infliction of emotional distress. We'll talk about the different cases that have interpreted this particular cause of action. Look at the illustration.
I do wonder, though, because the Laundries, they live in Florida. Bertolino is a New York lawyer. I wonder if they were referred to Bertolino or if they knew of him before. I was just kind of interested why they decided to reach out to a lawyer who practiced in New York and not like one in Florida.
That are in the restatement, all of which are informative as to what does and does not reach the level of intentional infliction of emotional distress. And our position at the end is going to be that the entire cause of action against Mr. Bertolino is due to be dismissed. And if for some reason the court doesn't get that far, there are certainly parts of the cause of action which clearly cannot be sustained, irrespective of any other argument set forth. I would also add, Your Honor, that we're mindful of the history of this case. And in making the argument today, we will absolutely cite to the cases that Judge Carroll cited to in his last ruling. The Liberty Mutual case in particular is very informative, and also talk about some of the commentary from Judge Carroll that, again, previously dates our time in the case. So, Your Honor, just to start off, before we dive into the Second Amendment complaint.
So I guess I noticed that when I was reading the court docs, Judge Carroll was the one that signed off on those. I'm assuming there's a new judge that's taken over the pretrial stuff. Is that what's going on? Hi, Mike Skidmore. How are you doing today? Because I don't think judges have a thing where they like stand in for another judge for like a, limited time period, right? They must just have a new judge that's taking over.
It's been around for a long time, but intentional infliction of emotional distress is a infrequently pled cause of action. It's a cause of action that does not have a great track record in terms of what constitutes it or not. But what is abundantly clear from both the restatement and the cases that interpret it is that the threshold for bringing it is extraordinarily high. And so as the restatement itself says, it's not been enough that the defendant has acted with an intent which is tortious or even criminal, or that he has acted to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Now,
what the Petitos are alleging, they're alleging that the Laundrie family and Steve Bertolino knew that Gabby was dead at the time, knew where her body was buried, but at the same time, they were okay with putting out that press release that was like, oh, I hope that Gabby's found and I hope, she's reunited with her family. So
generally, the case is one which the recitation of the facts to an average member of the community would arise his resentment against the actor and lead him to...
We'll get to the interesting part where one of the lawyers is going to argue, well, unite technically could mean pieces of body parts or like, yikes.
Exclaim, outrageous. So that is the threshold
stuck out to me.
for pleading intentional infliction of emotional distress. So with that said, Judge, I would like to focus on the Second Amendment complaint. And if you have our binder, it's tab C, which is where it appears. If you're looking at it electronically, I'm sure you have a way to pull it up. But let me know when you're there, and I'll move along.
Because I printed it, but I'm trying to find tab C here because it looks like
We have a small binder and a big binder. The big binder is the case law and some other materials. The small binder is the motions, a relatively short pleading that contains 6 counts. There are 2 distinct
I think that's the Petito family right there, and I think she has siblings as well.
Plaintiffs, Mr. Petito and Ms. Schmidt, and there are 3 distinct defendants, Mr. and Ms. Laundrie and Mr. Bertolino. Mr. Bertolino is introduced in paragraph 7 and 8, where he's identified as a lawyer who's licensed to practice in the state of New York. And then in paragraph 8, that at all times relevant to within the cause of action, Mr. Bertolino was acting as an agent for Christopher Laundrie and Roberta Laundrie. So the first alleged fact within the 4 corners of the complaint is that my client, Mr. Bertolino, the purported actor in the intentional infliction of emotional distress, is in a unique capacity compared to most who have come under this cause of action. He was an attorney providing legal advice and guidance and representing his clients. There's some additional information provided, Judge, but when we get to paragraph 20, this is where the background or the factual background starts to really come in. In paragraph 20, there's an allegation that on or about August 28, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, that he had murdered Gabrielle Petito. Again, it's an allegation in the complaint. Clearly, the plaintiffs can't have any firsthand knowledge of that, but they pled it. The court's bound by it for purposes of a...
So I don't know why the mic goes in and out like that. I think that happens every time they decide to zoom in the camera on like a certain party. I think that's when it keeps happening.
Motion to dismiss.
It's a little annoying, but...
It then goes on to say in paragraph 24, from August 27, 2021 until September 19, 2021, When Gabrielle Petito's remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabrielle Petito. And Your Honor, this is where it's important to give our first real focus to what's in the Second Amendment complaint. Traditionally, causes of action for intentional infliction of emotional distress require the actor to trigger the emotional distress. The actor says harsh words. The actor threatens physical violence. The actor embarrasses or humiliates a target with intent and malice. In this case, Your Honor, by the own pleading, the plaintiffs allege that as of August 27, 2021, they were rightfully so and understandably extremely distraught. And that becomes important, Judge Brewer, because that level of distress predates any conduct of Mr. Bertolino in this case. So as a starting point, again, four corners of the complaint, the extreme emotional distress, which is the ultimate byproduct of where we head to, predates Mr. Bertolino's involvement. Paragraph 25 then talks about the Laundrie family purportedly going on a family vacation. Paragraph 27, this is a
Yeah, they go on a family vacation for like a day or two.
reference to Mr. Bertolino, which really are few and far between in the Second Amendment complaint. It discusses that on September 13, 2021, Brian Laundrie left his home. Mr. Bertolino gave a press conference or interview a month or so later and described that he was grieving. I'm not sure that has a particular relevance to the case, but it's just one of the few paragraphs where Mr. Bertolino's statement or conduct is actually referenced. Where we get to paragraph 28, this is where the first purported fact setting forth a cause of action for intentional infliction of emotional distress against Mr. Bertolino is alleged. And it says on September 14, 2021, with full knowledge that Gabrielle Petito had been murdered by Brian Laundrie, and it is believed that they knew the whereabouts of her body, Stephen Bertolino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. And so again, if we back up to paragraph 24, the emotional distress started on August 27th.
Okay.
Now in paragraph 28, we're at September 14, and this is the first purported act or conduct of Mr. Bertolino. Procedurally, Judge, paragraph 28 only contains a portion of Mr. Bertolino's statement that day. Based on discussions with Mr. Riley, there's no objection to the entire statement coming in. It's actually Exhibit A to our motion to dismiss.
I saw the stipulation as to that. Okay.
Thank you, Your Honor. So I'll read the entire statement, understanding that there's only a portion of it in the Second Amendment complaint, but given the stipulation, it's all covered within the four corners at this time.
Understood.
So on September 14, 2021, Mr. Bertolino's office issues a statement, R.E. Ms. Petito. It says, statement for counsel from the Laundrie family. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. So let's look at that first sentence.
Man, I wonder if this is Bertolino's like biggest career regret right now. Like, oh man, why did I release the statement? We should have just STFU'd.
There's no objective way. There's no context or circumstance. There's no interpretation that can be given to that, which would ever rise to the level of intentional infliction of emotional distress.
Because, it could be possible if you really want to give the Laundrie family benefit of the doubt, which we should, here and there. It's possible that Brian may have not told them what happened, right? Brian could have been like, yeah, something bad happened, but maybe he didn't want to tell them that he actually murdered her, right? And they weren't really sure. They're like, hey, something bad happened to Gabby, but, I don't want to, she's not with me. And maybe they thought they're like, okay, did you severely beat her up? Did you dump her somewhere? Is she still alive? Maybe they didn't know the details of what he did to her. It's possible, when they made that statement. I mean, that's what we're going to find out in discovery and stuff, right? To see, any communications between Brian and his family. We're not going to know any communication between the family and the lawyer because that's all going to be privileged communication. But, maybe we'll have some text messages between Brian and his family where they're talking about hey, you got to leave where you are right now. Don't touch the body, or maybe go bury the body. I don't know. We don't know what kind of communication there is, right? But it's possible that the parents didn't truly know. It's possible that Brian didn't tell the parents. It's possible that the lawyer may have not known. But, yeah, I don't know. We'll see in discovery.
The next paragraph.
Hey,
It is our
KK,
understanding
hey,
that a search has been organized for Ms.
hi.
Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. And again, Your Honor, there is no interpretation or anything else that you could apply to that statement.
But I do want to mention that if I was the Petito family, it is not outrageous for them to believe that the parents knew, that the lawyers knew, and they didn't want to help, but they wanted to put out a statement to make themselves look good at the time being. So I don't think it's outrageous for the Petitos to be like, hey, I think Brian's family knew. And I think that's the reason why Brian's family decided to hire the lawyer on retainer the day after he came back. So I don't think it's unreasonable to believe what they allege in this lawsuit.
Which in any way makes it actionable under this particular cause of action.
We just don't
And then finally,
know
it concludes,
yet.
on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Before proceeding further, Judge, again, sticking to what's been pled here. In every instance of intentional infliction of emotional distress, the actor has targeted the recipient.
Okay.
In every case that's cited, in every illustration, in the restatement, there's always been a target, for lack of a better term, when it comes to words. There are other examples of intentional infliction of emotional distress. Showing autopsy photos was one of the cases that Judge Carroll cited too. But other than that very rare exception, there's all direct communications. And the reason there's direct communications, Judge, is because the actor has to intend the emotional distress to occur.
Okay.
There's intent, there's malice, and then there's recklessness. But in either of those or all of those scenarios, it's linear. The actor is doing something ultimately targeted towards the recipient of the conduct. Here, again, just sticking to the Second Amendment complaint, what's been alleged is that the Laundrie's attorney, Mr. Bertolino, acting in that capacity, put out a press statement to the general public at large. And no doubt an argument can be made that Ms. Schmidt
Maybe they could say it was reckless, right?
and Mr. Petito had access to it or reviewed it or read it or heard it. But in terms of the intent, in terms of meeting that high standard of the restatement, which is so high that even criminal conduct doesn't satisfy it, we have a lawyer
Hi,
or a
Sean.
client who's issuing a public statement that in and of itself is inactionable and totally appropriate. Again, what's within the four corners of the complaint. Paragraph 29, which now interprets that statement, alleges that for the Laundries and Stephen Bertolino to express their hope that Ms. Petito was located and reunited with their family at a time where they knew she had been murdered by Brian Laundrie was beyond outrageous. And again, that's an allegation. It's pled, and the court has to accept it, whether or not it's true.
Yep.
With that said, though, Judge, to express hope, there is not an example in the restatement, there's not a case, there's not a commentary, there's not a law review article, there's not a single situation which has preceded us here today before you in which someone expressing a hope, let alone an attorney, let alone in a general sense and not even a direct communication, there's not a single case which suggests that expressing a hope, no matter what the circumstances, could be considered intentional infliction of emotional distress. Furthermore, Judge, as we know from paragraph 24, the emotional distress already occurred. And what's not in the complaint is that the statement of September 14th.
So I guess what Bertolino's lawyer is arguing is that there's already emotional distress on the Petito family because they don't know where Gabby is. Gabby's missing, right? And so he's basically saying that, like, well, since the emotional distress was already there, it's not like my client created it because, you know, his statement came out 2 weeks after the emotional distress began. I think that's what he's arguing.
2021 actually caused emotional distress. So when we think about the elements of the cause of action, we first have to have the statement or the conduct, then it has to legally cause severe emotional distress. Second Amendment complaint alleges that the
But can't you, what about like if you added more emotional distress? I wonder if there's any cases where that happened.
Plaintiffs, Ms. Schmidt and Mr. Petito, were already severely distressed. It describes the statement on September 14, 2021, and then it does not allege that it caused severe emotional distress. It discusses purported ill will by Mr. Bertolino in making the statement. Without facts, it attempts to paint it with malice. Without motive, it attempts to paint it as improper, but it doesn't actually link it to causing anything. Paragraph 30 and paragraph 31 talk about the dissemination of it. They're really jurisdictional in nature. I presume there was a concern that there might be a personal jurisdiction defense, which we did not raise, but that's really the thrust of those counts or those paragraphs. Same for paragraph 34, talks about activity within the state of Florida. Paragraph 35 is interesting, Judge, because paragraph 35 talks
I'm
about
going crazy.
a
I feel
letter
like I hear a cat
on
meowing.
behalf of Ms. Petito's family on September 16, 2021, not to my client, but according to the Second Amendment complaint to the Laundries, in which they are asking for information about their daughter. Paragraph 36, it talks about, despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive, and if she was not, where her remains were located, Christopher Laundrie and Roberta Laundrie refused to respond to either Joseph Petito or Nicole Schmidt. Your Honor, again, Judge Carroll talked about that concept, the concept of inaction or not
We're in
responding
Florida.
last time, although while it was in the body of his order, it didn't actually make it to the ruling, which we'll talk about in a second. But paragraph 36 is not actually directed to Mr. Bertolino, so there would be no obligation for Mr. Bertolino to respond to the letter, understanding there was no obligation of anyone to respond to a letter in the first place. Paragraph 37, while Joseph Petito and Nicole Schmidt were desperately searching for information concerning their daughter, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino were keeping the whereabouts of Brian Laundrie secret, and it is believed they were making arrangements for him to leave the country. Again, no facts to support that. It's an allegation. True or untrue, the court has to accept it. Paragraph 38, Ms. Petito's remains were discovered on September 19. Also at that time, Judge, Mr. Bertolino issued another statement. The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. That's the second Bertolino statement described in the second amended complaint. And before proceeding further with that, as the court knows from our motion to dismiss, Mr. Bertolino is being sued for offering hopes and prayers. And hope is definitely something you can't get sued for, and prayers certainly isn't. And again, as of September 19, 2021, a statement by Mr. Bertolino after the fact that the Laundrie family was praying for Gabby and her family definitionally cannot be actionable as a cause of action for intentional infliction of emotional distress. So now we're up to paragraph 39, and the court's basically heard virtually the entire factual predicate. Whatever facts existed, whatever facts were put into the universe to support these claims, we've covered them.
Okay.
And paragraph 39 then tries to tie in causation for the first time. So remember, we don't really have a causal tie to the September 14th statement. There is no causal tie to the September 19th statement. But what paragraph 39 does is it essentially makes what I would call a refusal to disclose argument that's really separate and independent from the two statements I just read. Paragraph 39 says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt in not knowing the well-being or location of their daughter, and further knew that such mental suffering and anguish increased each day that Gabrielle Petito was missing. Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino further knew, and this is the key part, that they could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and location of the remains of Gabrielle Petito, yet they repeatedly refused to do so.
Okay.
So we have the actual conduct by Mr. Bertolino. Again, both statements, not targeted, not specific to the family, general in nature, made on behalf of parents who themselves were in an extraordinarily difficult situation. Some case law talks about the mental stresses that are on the parties. Clearly, the Laundries had those mental stresses as well. But where the prior paragraphs talk about actions, paragraph 39 essentially says, Mr. Bertolino and the Laundries, Mr. Luke, I'm sure we'll discuss this, what we're
Mr. Luke is the Petito, sorry, not Petito, the Laundrie lawyer.
suing
That guy
you
right
for
there.
is for not
Mr.
stopping
Luca?
the emotional distress, not causing it, but not stopping it. We started experiencing it much earlier in time, and
Okay.
you didn't stop it earlier by telling us the status of our daughter and where her body was. And again, Judge, for purposes of a motion to dismiss, whether or not any of this is factually correct, the court must accept it as true. So that's what we're dealing with. There is no cause of action for intentional infliction of emotional distress for not stopping it. There's a cause of action for causing it under incredibly severe and extreme circumstances, but there's no cause of action for not stopping it. And paragraph 39 is attempting to do just that. It's making allegations that because of inaction, not because of action, but because of inaction, the emotional distress that had been
Yeah, you're spamming about Brian Koberger's nose. Stop doing that.
ongoing since August 27, 2021 wasn't stopped
Behave.
earlier. And Judge, with all due respect, that's just not a cause of action that's recognized under
Yeah, slaughtered amoeba. They're gonna have to prove that down the road. So for what I'm understanding right now, the court has to assume what the Petitos are alleging are true. And what was the other thing? And any assumptions made have to be in favor of the Petitos. Yeah. Later on, that's when the Petitos are going to have to prove that Bertolino, the Laundries, that they knew that Gabby was dead, that they knew what Brian did to her, where the body was buried and all that. Yeah, I don't know. Maybe in discovery, they'll be able to maybe get some cell phone records, maybe some text messages, emails, messengers, whatever it is, that maybe shows that they talked about it. But I don't know. If it's just cell phone calls, yeah, it'd be really tough. So we have to, this is just for pretrial stuff. So this is for pretrial stuff. And then once it goes into the next stage, that's when it's going to all be heavily scrutinized. So
Florida law. It's not a cause of action that has passed.
this is like a civil case. From my understanding, civil case is very different than a criminal case.
At the Supreme Court or any of the appellate courts, it's not a cause of action that's described in the restatement. Second, it's not a cause of action that's identified.
So this is just getting everything ready before, getting everything ready to see if it even makes it to trial. But yeah, and like later down the road, if they're not able to prove that, maybe Bertolino and the rest didn't actually know that Gabby was dead, then I don't know, might not make it to trial, right?
In a treatise or law review article that we came across, but that's the cause of action in this case.
We'll see what happens during discovery. They're true. Definitely Laundrie's knew right away that she was dead because of when they got the lawyer. I think a lot of people make that assumption too, but it's possible that Brian could have just been like, hey, I need a lawyer. Something bad happened, but I don't want to tell you guys what happened. That's possible too. But am I going to side more with the Petitos right now? A little bit, yeah. Because if I was in their shoes, I'd be like, yo, you guys knew. You guys hired a freaking lawyer. You guys wouldn't talk to me. You guys blocked me on Facebook. Like, what's up, right? So I would make the same assumption as well. But it's possible that maybe Brian didn't tell his family and the lawyer. He was just like, hey, we need to get a lawyer. Like, something bad happened. I don't know.
And the only time, by the way, Judge,
We need more
where it alleges that
information.
anyone acted with malice or great indifference is right after that. Right after they refused to disclose. It
Yeah,
says,
that's not unreasonable at all,
Roberto
Sean.
Laundrie, and
Not
Stephen
unreasonable at
Bertolino
all.
acted with malice or great indifference to the rights of Joseph Petito and Nicole Schmidt. Not with the September 14th statement, not with the September 19th statement, but with this concept of not disclosing something that they purportedly knew. 1 through 39, Judge, that is all the alleged facts that this court has to work with. Paragraph 40 then basically sets forth what the alleged wrongful conduct is. To briefly jump ahead, when you go to count 3, which is against Mr. Bertolino, and you go to count 6, which is against Mr. Bertolino, they consist of 2 paragraphs. Basically, we incorporate paragraphs 1 through 40, and then Mr. Bertolino, as a direct and proximate result of the willfulness and maliciousness of Mr. Bertolino, and then they say it caused damages. So again, the actual counts themselves, which don't have a title, which don't say they're for intentional infliction of emotional distress, which don't themselves identify what the purported wrongful conduct is within the counts, they're silent on that. So you have to go to paragraph 40 and piece paragraph 40 into counts 3 and 6. Paragraph 40 is a commingled count, which is obvious when we get to the A, B, C, D, E, and F part, because it essentially describes conduct for Christopher Laundrie, Roberto Laundrie, and Stephen Bertolino as if all of them were acting in an identical manner. But nonetheless, what are the causes of action in this case, or what are the components that are alleged for intentional infliction of emotional distress? 40A, failing to advise the plaintiffs that Gabrielle Petito was deceased. So again, a failure to take action, a failure to disclose count. Again, as discussed by Judge Carroll in his order, there is no case law to support that. There's no argument that can be made to support that. Judge Carroll's comment was that if those were the only counts, the entire matter would have been dismissed. But yet in the order just said denied. And this is one of the difficulties with the way this case is pled. It really should be 1 count for each purported act of intentional infliction of emotional distress, because then that way the court could determine as a gatekeeper.
This is ongoing. The trial initially was going to happen in August of this year, but it's been pushed to next year. I think like around Chad Daybell's trial, June 2024. So this is ongoing. It's a civil trial.
Does this count stay or not? And then for some reason it stayed for summary judgment purposes, we could say, well, count 1, which is the failure to advise, here's our motion on that. Because the actual counts don't describe the wrongful conduct, and because paragraph 40 just lists it as an A through F, it does make it difficult to manage in terms of issuing orders and approaching the pleadings. But in any event, we're treating it as if A, B, C, D, E, and F are all individual or separate and distinct allegations of intentional infliction of emotional distress, because that's how they're described. But in any event, paragraph 40A, failure to advise. Paragraph 40B, failing to disclose to the plaintiffs the location of Gabrielle Petito's body. Again, another allegation of inaction, not an allegation of conduct that was intentional or directed, but simply inaction, discussed by Judge Carroll last time. Paragraph 40C, taking a family vacation. Clearly that can have nothing to do with Mr. Bertolino, but again, because of the way paragraph 40 is pled, it applies to him, even though obviously it can't. Paragraph 40D, blocking access to cell phones. Again, that one can't apply to Mr. Bertolino. 40E and F. This is the...
Yeah, I don't know how they're going to be able to figure out what Bertolino knows and doesn't know, because it's going to be under client attorney privileges, right?
September 14th statement of hope in 40E. Paragraph 40F, this is the September 19 prayers after Ms. Petito's remains were discovered. And Judge, that is the entirety of the facts and the theories and the allegations and the links. So linking allegations to conduct, linking conduct to causation, linking causation to damages, which is what's supposed to happen in the Second Amendment complaint. Those links are just not here. And so without going beyond the 4 corners of the complaint, on both sides, because obviously Mr. Riley can't stand up and fill in the blanks. They're either in the Second Amendment complaint or they're not. Based on what's in the Second Amendment complaint, and more importantly, based on what's not in the Second Amendment complaint, the Second Amendment complaint against Mr. Bertolino can't stand. Turning to the law, Judge. The case law is clear that the court serves a gatekeeper function when it comes to intentional infliction of emotional distress.
Hi,
In the Liberty
Queen.
Mutual case, and Your Honor, this is in our case law binder, tab 66, but this is a case that Judge Carroll cited quite a bit in his order. It's Liberty Mutual versus Stedman. The site is 968 Southern 2nd, 592. It's a Second District Court of Appeals case from 2007.
If you need a counsel, what did he say the counsel was for? So he could have either just been like truthful with it, be like, hey, mom, dad, I murdered Gabby. I don't know what to do. Mom, dad's like, okay, let's get a lawyer. He could alternatively, if you give him benefit of doubt, you know, best case scenario, could have been like, hey, mom, dad, can we hire a lawyer? Mom, dad's like, why? Gabby and I got in a fight. I hurt her. She's severely injured, but I left her. Maybe they don't know that he killed her, right? We don't know. We don't know what went on. What's the conversation? We don't know how much the parents know. A lot of us are like, yeah, we're pretty sure that he told the parents. We're pretty sure that the lawyer knew, right? But we don't know that for sure, 100% sure.
Talks about whether or not a complaint can state a cause of action for intentional infliction of emotional distress. In this case, as every other that interprets it, identifies that threshold as a question of law for the court. So oftentimes we find ourselves at motions to dismiss where the court asks me, you know, Mr. Meltz is...
Well, this hearing has a couple of purposes. So right now, Bertolino's lawyer is arguing to dismiss the case against him. Laundrie's lawyer is going to go up there and maybe argue the same thing, even though they already had theirs denied by the previous judge. And then the Petitos, they want any transactions more than $10,000 that the Laundrie's made to be sent over to them. And then the fourth one was the letter. Was there any other ones? Those are the four that I remember. There's a letter that Roberta Laundrie wrote to her son, and they want that to be admitted into evidence.
Not more of a summary judgment argument, isn't it factual? Whether or not a complaint sets forth a cause of action for intentional infliction of emotional distress is a question of law. So it's clear from the case law that Your Honor, at this somewhat early phase in litigation, has the legal authority and the legal requirement to make that determination. It's not for a jury to make at a later day. And it's also something that no deposition or discovery is going to affect because, again, we have to look at the four corners of the complaint and determine, does it meet this standard? And as the court in the Liberty Mutual versus Stedman case discussed, behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That's the standard. So we have to take that standard and we have to look at what's alleged in the Second Amendment complaint and see if it meets that standard. In applying that standard, the subjective response of the person who is the target of the actor's conduct.
Yeah, the letter, the letter sounds really bad. Yeah, it's a pretty bad letter. It could just be really unfortunate timing because she's saying that, oh no, the letter was written before they went on this trip. We have this inside joke. It's something that only us would understand in the inner circle. Like, yeah, the letter sounds really, really bad. But, you know, we'll wait.
Does not control the question of whether the tort of intentional infliction of emotional distress occurred.
Hi, Adam.
Rather, the court must evaluate the conduct as objectively as is possible to determine whether it is, quote, atrocious and utterly intolerable in a civilized community, whether conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law, not a question of fact. So, Your Honor, you have the task and the burden of reviewing the language in the paragraphs that we just read through and determine whether Mr. Bertolino, offering hope on September 14th and offering prayers on September 19th on behalf of his clients, as their attorney, as their agent, in a general sense, non-targeted, with no reason, motive, or any other factor to make these mean-spirited in any way. But you have to determine whether those allegations rise to that level of utterly intolerable in a civilized community. And again, Judge, hopes and prayers can't rise to that level. And the allegations that there was a duty somehow not to be silent, but to disclose, that there was a duty to make the plaintiffs aware of whether or not Ms. Petito was alive and if she wasn't, where her body was. That's just not a duty that exists under the law, and it's not a cause of action that exists under the law. And again, Judge Carroll incorporated that in his last ruling, and there's no case law to suggest anything to the contrary. We've cited other cases, Judge. They all say the same thing. It's a tremendous burden to show truly horrific conduct. That burden has not remotely been met here, yet alone tied into legally causing actual severe emotional distress or damages. Separate and apart from that, Judge, and I'm winding down, despite the fact that is not properly alleged and can never be, and despite the fact that the law creates a burden that the plaintiffs can't hurdle. We also point out, as set forth in the restatement in various other cases, that separate and apart from those issues, even if the court were to find that this conduct was utterly atrocious, an attorney who was functioning as Mr. Bertolino did, who is representing the Laundries, who themselves are unwittingly and unasked for part of a horrific situation in which all of the events are ongoing as they were, it is legally permissible for Mr. Bertolino, as the Laundries attorney, to make statements like the ones that he did. And the restatement of torts is clear that when an actor acts in a legally permissible way, there cannot be intentional infliction of emotional distress. They give examples of a landlord who knows a family's sick, but they didn't pay their rent, so they're evicted. The landlord clearly knows that putting them out on the street would cause intentional infliction of emotional distress, but they were legally entitled to do so.
Jeannie, I think that's possible too. Jeannie writes, if nothing else, the letter proves the mother knew that there was abuse going on. She blamed Gabby for it, gave her baby a pass, and what they should have done was tell Gabby to go home. That's possible too, but I think that's too much assumption to be making. We don't have enough information on that yet, but I think that's one thing that's possible.
In the various insurance company cases where the insurance company would ask about whether someone qualified for Medicare or whether they met certain conditions, even though there may have been a denial or delay in treatment, they couldn't be held responsible because they were legally permitted to do so.
But you know how people joke all the time, amongst friends, right? Or maybe even with siblings, right? Oh yeah, if your boyfriend ever cheats on me, let me know, because you're gonna find his body 6 feet under in the desert somewhere. We always make jokes like that, right? It's possible it could just be a joke as well. I don't think that's anything too crazy. People joke about that, right? Oh, they're gonna be 6 feet under. You better not fuck with my daughter. You better not cheat on her. They make that joke all the time. Maybe even in a letter. Yeah, we don't have the full context of the letter yet. We only have bits and pieces of it. I think the context is going to matter a lot. I think right now it sounds really, really, really bad for Roberta, but I do want to get my hands on that letter. I don't know if we're ever going to see it anytime soon.
To suggest that Mr. Bertolino, as the Laundrie's attorney, wasn't legally permitted to make a statement to the general public of a hope and a prayer in an extraordinarily difficult circumstance would suggest that any lawyer acting in that type of circumstance would be at risk for unintentionally causing emotional distress or unintentionally.
Wait, it is? Oh, wait, should we read it? No way. Oh, snap. They have the letter already? Oh, shit, it is here. Oh, all right, let's stop speculating. Let's read the damn letter. Thanks, Queen. Who pointed that out? Oh, Queen, thank you. I do appreciate it. Oh, Jesus. Should I read the handwriting version? Oh, what is up with this glare? I just want you to remember I will always love you, and I know you'll always love me. You are my boy. Nothing can make me... Fuck, I can't read it. I just want you to remember I will always love you, and I know you always love me. You are my boy. Nothing can make me stop loving you. Nothing will or could ever divide us, no matter what we do or where we go or what we say. We will always love each other. Also, does anyone know where this letter was found? Was it found on Brian Laundrie's dead body? Was it found in his personal belongings somewhere? Where was this letter found? Was it in the van? I think that'll be really important too. If it was found on Brian's deceased body, then that looks way, 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 way worse for Roberta. If you're in jail, I will bake a cake with a file in it. If you need to dispose a body, I will show up with a shovel and garbage bags. If you fly to the moon, I will be watching the skies for your re-entry. If you say you hate my guts, I'll get new guts. Okay. Remember that love is a verb, not a noun. It's not a thing. It's not words. It's actions. Watch people's actions to know if they love you, not their words. Therefore, I am certain that neither death nor life, nor angels, nor the ruling spirits, nor things present, nor things to come, nor powers from above, nor powers from below. Oh, this is God. Should I read this? Nothing the entire create the world can separate our love. Neither hostile powers nor messengers of heaven nor monarchs of earth. Nothing has the power to separate us. Romans something. Is that it? Nothing can separate us, not hatred, not hunger, not homelessness, not threats, not even a sin, not the thinkable or unthinkable can get between us, not time, not miles and miles and miles. Brian Christopher Laundrie, burn after reading. The letter makes no mention of Gabby, has no date, no reference, when it could have been written. I don't know. That's hard. I think she. Yeah, that's tough. I don't think I can read this letter and definitely, confidently say, yeah, this letter was written after he murdered Gabby, and this is her way of showing that she was a ride to. Can parents be a ride to die? What's it called again? Who writes like that? Hey, people do though, you know, like Johnny Depp. He writes some weird shit sometimes too, but some people are just very artsy, poetic. I don't know what's the term for it. It's weird, but I don't think it's like anything too crazy. I don't know. Yeah, it's a weird letter. It's possible that she wrote it after Gabby was murdered, and it's also possible that she wrote it before the whole thing happened. And you know, she's just very. It's just a very unfortunate timing. I don't know. It just sounds bad, but it makes for great headlines, right? Like, oh my God, Brian Laundrie's mom was down to hide a body for her. Was down to hide a body in a garbage bag. Yeah, I don't know.
Offending someone or unintentionally causing someone ill feelings or grief. There's no way to navigate that situation. You have two families who are going through something.
Chopper, I made a recap video yesterday. Just recapping what happened so far. You can watch that.
No one can prepare
Hi,
for.
Janine.
Something that no one should prepare for or ever expect. But both families have their own issues, and the Laundries needed Mr. Bertolino. Mr. Bertolino acted as their attorney, and as the Second Amendment complaint says, at all times he was acting as their agent, and as such he was legally permitted to make the statements that he made, which themselves are not actionable. Finally, Judge, I do note that Judge Carroll addressed the statements at issue, not really the September 19th statement, but the September 14th statement, where he talked about context. I would note, though, that Judge Carroll did not talk about context.
I'm actually kind of curious, though, because if this is a woman that writes things in letters, that must mean she has other letters that she's written him or to other family members. So what she could do, she could get other letters that she's previously written and be like, hey, look, this is my style of writing. See, it's not abnormal. I write like this all the time.
With Mr. Bertolino as a party, as a defendant. And also, Judge Carroll's discussion about context didn't factor in all of the other elements, such as causation, such as intent, such as recklessness. He simply addressed what was pled and filled in the context. With that said, though, Judge, the full statement creates a much bigger context, which Judge Carroll did not have the benefit of last time, and which I think contextually makes the statement much more understandable and benign. And then secondly, while Judge Carroll discussed the Stedman Liberty Mutual case, he didn't talk about that part where it said, in applying the standard, the subjective response of the person who is the target of the actor's conduct does not control the question. Nor did he address that the plaintiffs weren't the target, because again, the statement itself was publicly disseminated. It's an emotional case. The issues are complex. There's no bright line rule. It's very doubtful we'll ever see.
I think writing letters, like handwritten letters, just has like a personal touch to it. That's probably what she probably may have wanted to do. I have friends that write me letters, you know, when I'm like, well, you could have saved the postage and you could have just like said, hey, thank you for the gift, or thank you, or happy birthday, something like that. I have some friends that, you know, will buy some nice paper and they'll write the letters out. I get them too. So I don't think it's something that's like super out of the ordinary. And then also, don't get me wrong, even though there are times where I'm giving Brian's family benefit of the doubt, whatever, or arguing like what could possibly be their side, I still think what they did was still really fucking disgusting, because they must have fucking knew that something really bad happened to Gabby and they didn't give a shit. They went on vacation, all that. Like, I still think what they did was really fucking morally disgusting. So, but I'm just still trying to, you know, not completely just trash on them just because I fucking hate them, right?
This exact fact pattern again. But none of that changes that the Second Amendment complaint still has to set
I was
forth a
practicing my
recognizable cause of
cursive.
action.
I love cursive.
And it doesn't.
But it is. You're right.
And it's just white or black, Judge. And so with that said, the court needs to dismiss it. At a minimum, if the court doesn't dismiss it, then clearly those parts that need to be dismissed need to be dismissed. Those parts being the failure to disclose, the failure to act, the failure to speak, none of which is supported by law. So our position would be the entire Second Amendment complaint, or rather the counts against Mr. Bertolino, but I'm sure Mr. Luca will have a similar argument. But the Second Amendment complaint against Mr. Bertolino needs to be dismissed in its entirety. If not, it certainly needs to be pared down. And as to prejudice, Judge, I would note that we are on the Second Amendment complaint. There's been 2 prior amendments. This is the 3rd opportunity to set forth a cause of action. The framework to the count was clearly argued last time. Judge Carroll's order was instructive. The case law has been at issue. Presumably, if there were better allegations that could be met against Mr. Bertolino, they would be in the Second Amendment complaint, and they're not. So based upon that, our position is the Second Amendment complaint against Mr. Bertolino should be dismissed, and given the procedural history in the case, should be dismissed with prejudice. Thank you.
All right, thank you so much, sir.
All right,
Riley,
Mr.
did you
Lawyer.
want to let Mr. Luke go when you respond to both of them, or did you want to go now and then?
Since their arguments are basically the same, I'm fine with Mr. Luca going now.
Okay. Mr. Luke,
Thank you, Your Honor.
All right, so this lawyer, this lawyer definitely said some words that perked my attention when I was trying to multitask a little bit. This is a very interesting lawyer right here. We might get a little pissy.
Please the court.
Absolutely.
Your Honor, I will
This is the Laundrie's lawyer's
try not to replow
lawyer.
the same ground as Mr. Meltz, but I'm sure I will. So I just want to apologize in advance. So, Your Honor, in the plaintiff's response to our motion, they assert
It's
that we are
not?
simply trying to overrule Judge Carroll's order. Now, while we are asking the court to dismiss the action, which Judge Carroll did not do, our arguments in this motion are, for the most part, issues Judge Carroll did not consider. Most specifically, as Mr. Meltz pointed out, his client wasn't a defendant at that time. But there are other issues for my clients as well. At the first motion to dismiss hearing, the plaintiff's theory, at least as we interpreted it, was that the Laundries caused them emotional distress by failing to communicate about Brian and Gabby.
I don't see anywhere else about the letter. There's a picture of the letter. Double-sided. That's it. That's all I got. What do you have?
Specifically to disclose Gabby's whereabouts. And that theme is repeated again in the Second Amendment complaint and also in their response to our motion to dismiss. So our primary focus at that first hearing was that the Laundries had a number of constitutional and other legal rights that protected their communications and activities, and thus they had no duty or obligation to act in a certain way or to communicate information. Now, Judge Carroll did agree that the bulk of the plaintiff's allegations did not support the cause of action because the defendants had no duty to speak under the circumstances. Now, I don't know if the court wants me to re-argue those points or if you would prefer that I just pick up from where Judge Carroll's findings.
I've read Judge Carroll's
Okay.
findings in the past, and
The judge's like, no, move along.
I'm reading them again this morning. So if you want to take over that, you can. But it's your case to argue. So.
Absolutely. Thank you, Your Honor. And if you do have any questions about what we argued at that point, how Judge Carroll came to that, I'm happy to answer.
I'd be happy to ask.
Yeah, of course she's going to ask. She's the judge. She's the boss.
So at the first hearing on the motion to dismiss, Mr. Bertolino's statement at that time was really just one of many allegations. And admittedly, we didn't focus on it in our argument, probably as much as we should have. However, Judge Carroll found that of all the allegations, because Mr. Bertolino's statement was an affirmative act, which, although in isolation did not rise to the level of outrageous conduct, that it's possible the plaintiffs could develop some context for it that could render it outrageous. Like I said, we didn't concentrate as much attention on the statement as the first hearing as we should have. And knowing now that it was the critical allegation in the case, we should have focused our arguments on that topic. So that's what I'll do now. In that regard, we're not asking the court to overrule Judge Carroll because Judge Carroll did not have the benefits of a lot of the arguments we're going to assert today. First, Judge Carroll did not have the benefit of Mr. Bertolino's entire statement. Plaintiffs only included the one paragraph out of the 3 paragraphs in the original complaint and also in the Second Amendment complaint. And as Mr. Meltz said, by stipulation, the court can consider all of those paragraphs for purposes of this hearing. Second, Mr. Bertolino's statements were legally protected both by the privilege afforded to the exercise of permissible conduct when it comes to a cause of action for intentional infliction of emotional distress, and also the litigation privilege.
He actually looks like he's like going to a wedding. Got a little light blue suit on, pink tie.
Third,
Looks like one of
whether
the
the
groomsmen
statement
or something.
alone, as opposed to the other allegations that Judge Carroll found did not support the cause of action, was either produced or substantially contributed to producing the severe emotional distress.
How about some freshly baked cookies with a fucking needle in it?
Fourth, whether Mr. Bertolino's public statement, again, as opposed to the other allegations, satisfies the requirement that it be directed at the plaintiffs and in their presence. And lastly, the addition of the allegations against Mr. Bertolino renders the allegations against the Laundries implausible. So first, Your Honor, Mr. Bertolino's statement is not outrageous. And Mr. Meltz read the statement. I won't read it, but I will talk about it. Whether the conduct is outrageous is a matter of law for the court to decide. And the plaintiff's subjective reaction to the conduct does not control. The statement itself must be objectively outrageous. Generally, an outrageous act is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. If I recited Mr. Bertolino's statement to the average member of the community, their reaction would not be to exclaim, outrageous. they would probably think it sounds like a statement they have heard many times before by an attorney in a public comment about a case. Basically, a statement that says nothing of substance and is an attorney just trying to say something favorable for one of his clients.
I don't know. Maybe he shouldn't have. He should have just shut the fuck up.
In paragraph 39, which is on page 19 of the plaintiff's response to our motion, they acknowledge that the statements.
But to be fair, though, I've never heard of a case like this before. Not that I'm like knees deep in cases and stuff all the time. Yeah, I've never heard like an attorney getting sued for something like this. I was like, damn, this is interesting. Hi, Neko. How are you doing today?
When I say statements, I mean the September 14th statement and the September 19th statement, without context, seem to be an appropriate expression of sympathy and understanding for the trauma which the Petito family was undergoing. Had they been said by anyone else but the Laundries or Bertolino, they would be interpreted as genuine and sincere. So basically what the plaintiffs are saying is the statements are not outrageous, but the plaintiffs did not interpret them as genuine and sincere.
Yeah, because, okay, this is also possible as well, right? Let's say that Roberta did write that letter to Brian after the murders happened because she knew and she was going to back him up no matter what. I feel like the Brian guy, wouldn't he burn it so there wouldn't be evidence left behind? That's why I'm like, if he did get it before the murder happened, then it's possible Brian was just like, you know what? I'm too lazy to burn the letter. Like, I don't know. Burning letters is kind of messy. It smells. It's annoying. I'd rather just throw it away, right? But he probably just kept it. So I don't know. That's one possible scenario.
And thus it caused them distress. So going back to the standard, Your Honor, objectively, the statement is not outrageous, but subjectively, the plaintiffs interpreted it as such. That's not the standard for liability. The subjective interpretation of the plaintiffs does not control. It is an objective standard, and by objective measure, the plaintiffs even acknowledge that the statements are not outrageous.
Is it objective just taking the
Hi, James.
Just taking the statement as it is without any context, or is it the objective person sitting in the same exact contextual position as the plaintiffs?
That's an interesting question, Your Honor.
When people say, that's an interesting question, that's a question they're like, fuck, I don't want to answer this. So I'm going to rewind what the judge said really quick because I like what she said.
Are not outrageous.
Is it objective just taking the statement as it is without any context, or is it the objective person sitting in the same exact contextual position as?
Because obviously, if you take the statement with the context, yeah, it could be pretty fucked.
The plaintiffs.
That's an interesting question, Your Honor.
That's a politician answer. You know what? That's an interesting question. Let's get to it right now.
Because the way that the case law frames it is an outrageous act is one in which the recitation of the facts to an average member of the community. So I would submit that the standard takes into account what an average person would think within the community, not necessarily the plaintiff in that position considering whatever the conduct is that's alleged to be outrageous. Now, I don't have a specific case that discusses exactly how the court would consider that issue.
Question, because that's what I said. You said that, but has any court said that?
Your Honor, other than the quote that the outrageous act is one in which the recitation of a facts to an average member of the community, that is a citation.
Okay. You probably already said it, but just in case I.
Hang on, let me pull that up, Your Honor.
All right, pull it up, sir.
And I'm guessing just off the top of my head that it's probably the Metropolitan case, but I will double check that.
We got all day, sir. No, we don't.
Lions Incorporated versus King. And the site for that is 557 Southern 2nd, 574, page specifically 576. And that's a Florida Supreme Court case from 1990.
Okay. Thank you.
All right, she about to fact check that.
And Your Honor, I would also.
Oh, dude, I could totally believe that. We don't have a relationship with mother-in-law because she's fucking batshit crazy, all right? Fucking crazy. Listen, anyone that's toxic in your life, you fucking cut them out. You don't got to deal with them, okay? You ain't got to deal with them. You can cut them out if you want to. Family doesn't mean shit. It's great to have family that's wonderful. You know, it's good to have family relationships. But, you know, if they fucking suck, bye-bye. Peace. She wraps them, brings them to prison, reminding you how proud she is that you're in prison. Wait, what are we talking about? I'm out of the loop.
In addition, again, citing the Metropolitan Life Insurance Company versus McCarson, the site for that is 467 Southern 2nd, 277. And that's, again, a Florida Supreme Court case, and it's from 1985.
467?
467 Southern 2nd, 277.
Okay, perfect.
Specifically page 278. And again, that's the case that essentially adopted the cause of action for intentional infliction of emotional distress in Florida. And in that case, Your Honor,
in a very simplistic way, Chopper, yes. But there's a lot of events that happen in between that is the reason for this lawsuit.
Again, one of the standards that the court has to consider is the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Again, Your Honor, sort of referencing that the standard involves what a person within the community would think of it, not necessarily how a specific person in the specific position of the specific plaintiff might consider that particular conduct. But Your Honor, if you'd like, I can do some research after the hearing and submit a supplemental to the motion to try to
okay.
pinpoint that issue.
I can probably do it myself. That's the question.
Judge's like, nah, I'm good. I just want to make sure you're on your toes. Yeah, I'll give a quick little recap. I did make a video about this that I posted yesterday. You can watch it as well if you want more details. This is about the couple. Roughly 2 years ago, they decided to embark in a van life journey. If you guys ever heard of van life, it's when, people kind of drop everything they're doing. They get a van, they kind of deck it out, and they live out of their vans, and they become like influencers documenting their journey, their life, their road trips and stuff like that. They go to different states. They stay in state parks like that. A lot of it's really glamorized, but that's a whole different topic. I'm not even going to talk about it today. But yeah, they wanted to document, their couple-y stuff, and roughly, maybe about like almost 2 months in, he murders her, and he decides to come back with her van. Everyone's like, where's Gabby? He goes in hiding at his parents' house. Gabby's parents are are they both in New York? Maybe. But maybe they're both in New York. They're trying to get in touch with, his family. They live in Florida. And they're essentially ignoring. At some point, they block the family on Facebook, calls, whatever it is. Family can't get in contact. And keep in mind, it's not just like two people that are just like, boyfriend, girlfriend. They've been together for a couple of years. They've been engaged for a year. And actually, I believe Gabby was living with Brian Laundrie's family for, I don't know. Someone kept saying like a year. I don't have that in writing somewhere, but people kept saying it was a year. So take it with a grain of salt. But what essentially happened is that the family stayed silent. Everyone was inquiring about like what happened to Gabby. This got really big on social media. I wasn't covering at the time when it was happening. I think like I was just like listening to it, here and there. But yeah, everyone was wondering what happened to Gabby. And then about 2 weeks in, the family gives a press statement through their lawyer saying that like, oh, I know you guys are searching at the park. I hope you recover. I hope you find Gabby, and I hope she reunites the family, right? Something like that. And then Brian goes missing. They're like, well, where's Brian? Well, Brian is found, actually, before they find Brian, they actually do find Gabby's body. They found Gabby's body. She had blunt trauma to the head and neck, died by manual strangulation. They ruled it as a homicide. And then a month after that, that's when they found Brian's body, left a suicide note detailing what happened. But honestly, I don't know I don't believe his side of the story. I don't know. I think it's all BS. And he killed himself. Yeah. And so right now, the Petito family, which is Gabby's family, Petito Schmidt family, they are suing the Laundrie family. And they're basically saying, they're like, hey, you guys came out with this press statement when y'all knew that Brian had killed Gabby. You knew that we wouldn't find the body. You knew she wouldn't reunite with us. So this causes severe emotional distress. And that's basically what they're suing for. There was another lawsuit that happened. It was for wrongful death lawsuit, and they were awarded $3 million, which is not really $3 million. It's just an arbitrary number that they chose. They won that one. It was like a settlement. And then right now, what's happening is it's the emotional distress lawsuit. So this is all civil stuff. We're not in criminal trial or anything. There's no criminal trial happening because Brian Laundrie, fucking coward, shot himself. He's gone. Hi, Dweezil. How are you doing today? How's it going? Sorry, that was like a rough recap, but I feel like my brain has been a little bit like a little clunky lately. Van life stuff. He was such a coward. I would bet he left that letter so that he's not blamed for all of the possibility. Like, look at what he did. He knew that he had so much hate and vitriol against him. He decides to off himself. Who's going to get the blunt of it? Or brunt? The blunt? The brunt. Is it the brunt of it? Brunt, right? Who's going to get the brunt of it? His family. Look at the baggage that he left for his family to deal with. Yeah, what a fucking coward. But, people are like, you know what? Brian Laundrie was a coward for this, and so are the parents. And I could sympathize with that. But, yeah, anyways, this is where we're at right now. There's no criminal trial. Brian Laundrie's gone. But we do have the civil lawsuit. Remember that before Brian got to Florida, yeah, oh yeah, they had a camping trip too. The optics are pretty bad on that. So Brian came back. Gabby's family is like, where's Gabby? Where's Gabby? They were ignoring. And, you know, I think about like a week later, they go on a camping trip, family camping trip for like a day or two. And yeah, the optics look really bad. I could also see that they were just like, hey, Brian, before you go to jail, let's just have one big family gathering and act like everything's okay while your fiance is missing somewhere. Yeah, the optics are pretty bad. Brunt. Okay, the brunt. Yeah. They're usually cowards. Yeah. And I do want to point out, like, we do have body cam footage of times where, because, you know, there were cops called for one incident where they were fighting on the side of the road. But what's interesting is that the 911 caller didn't say that Gabby was hitting Brian. The 911 caller was saying that Brian was slapping the shit out of Gabby. And there was another incident. I don't know if we want to believe this one, but there's another incident that a couple said that they saw at the Tex-Mex restaurant. They said that, you know, Gabby was in tears and Brian was very angry looking and he was very agitated. He was like kind of like giving the staff workers attitude. But yeah, I don't know. It kind of sounds like Brian's the aggressor, but again, we don't have enough information because Gabby did mention in the body cam that, you know, she did hit Brian first, apparently, but I don't know what her definition of hit is, right? It could just be like, you know, pushed back like this. But meanwhile, Gabby had like blood on her face. It seems that like he like grabbed her face from behind. Like, who fucking does that? I don't know. But yeah, I don't know. Young, stupid. He took the coward's way out. Do not camp with crazy people. It's not fun. But yeah, there's a lot of information that we don't have. But we definitely know Brian is definitely a coward.
That it appears to me that Judge Carroll has already answered that question from a motion to dismiss standpoint.
Oof.
That's where I'm having some trouble with your argument. And I understand that you're saying, well, now we have the full statement.
This judge is like, hey, just because Judge Carroll ain't here, don't mean you could be messing with me, okay? Can't be pulling over that shit.
But
you can't be pulling that shit with me.
you're saying that the full statement changes the context in which the middle part should be read.
Yes, Your Honor, that is my position.
All right.
Because I'll get to that, but essentially my position is that taking that middle paragraph in isolation, without the two paragraphs that both precede and follow it.
Hi, Jane. Wait, your boyfriend, not ex-boyfriend? Anger issues? Yeah. Listen, if you got anger issues, you got to get some therapy, man, because you got anger issues in your 20s, you know, you don't change. And if you don't want to get therapy, that shit is it's gonna fucking, what do you call that term? Where rolling ball, it's gonna be a fact. What's the word that I'm looking for? Oh my God, I can't think of it. Can't think of the term. But basically, if you have issues and you don't want to work on it or you don't want to seek therapy and you don't want to change, what's going to happen is you're just basically it's going to affect the next person that you deal with, the next girlfriend, the next boyfriend. If you guys ever have kids, you know, it's going to affect them because if you never change yourself, then you're just going to have fucking so many people that you come across in your life.
Because those two, the first and the third paragraph really do provide the context for why the plaintiffs wouldn't necessarily regard that statement as what they claim it to be.
Snowball effect. Yeah, it's gonna affect your other relationships and stuff like that. Yeah, you gotta like stop it. Or one day, you know, maybe you're at a fucking gas station and someone steals maybe you're waiting in line and you're next to, you know, fucking fill up your gas and then someone wasn't paying attention, they cut in front of you and you fucking just go ballistic and you fucking lose it because you've had years and years of this pent up anger that you didn't know how to deal with in a healthy way. I don't know. And you might have them in the fucking news one day. So get your shit together.
In other words, the explanation that Mr. Bertolino offers sort of puts it in the position of, hey, we know this statement might not be enough, but based on the advice of our attorney, it's all we can say. That's what the last paragraph of the statement says, which is important for our purposes because really what the plaintiffs are saying is you should have said more. And that's really what Judge Carroll said too, is there could be context where perhaps they should have said more in the statement, or the statement should have been worded differently, whatever it might be. Considering the context of that last paragraph, it's informing the plaintiffs, I'm sorry that this statement may not be to your liking, but based on the advice of our attorney, this is all that can be said. So that's our position. And Judge Carroll didn't consider that position at all because the full statement was not in the record at that time. We didn't argue those other paragraphs at all.
Yeah, it's tough, Jane. Like my mom has been in a really shit relationship for like, I don't know, is it like 25 years now? Maybe 25 years, 20, 25 years. And even she can't figure out how to fucking leave that relationship. And she knows it's bad. And I'm like, bro, I don't know why you put yourself like through this, why you go through this. I don't know. Like, and she put us through, which I fucking hate too. But I don't know. It's tough. It's very tough indeed.
And Your Honor, we believe that this is a fundamental flaw in the plaintiff's cause of action, is that it is based on their subjective interpretations and general cynicism for anything the Laundries did. For example, they claim that the Laundries' visit to Fort DeSoto Park was outrageous. And they claim that Mr. Bertolino's September 19th statement, in which he offers condolence and prayers for Ms. Petito's death, that's outrageous. That's a subjective assessment. I mean, I don't know that there's any reasonable person that would objectively think somebody going to a park would be outrageous. Your Honor, I really think that, I know the plaintiffs allege a lot within their complaint, maybe not as much as they should to beat this cause of action, but the statement by the plaintiff's attorney that's alleged in paragraph 35 of the Second Amended Complaint.
Yeah, I was in like a pretty really bad relationship too. I know like from the outside in, it's so easy to be like, you can do better. There's better people out there. Why do you put yourself through this? Like, but while you're in that relationship, I feel like your field of view is so like parochial. You know, you're only seeing you and the other person, and you're like, I love this person this much. That's all that matters, right? I feel like it's really, really hard to really have pride in yourself and understand your self-worth until something big happens to you. Like for me, I think it was like one day I went into work and I was like, you know what? Like, fuck this shit. I'm like in my teens. Yeah. What am I doing here with this like fucking loser, this fucking drug addict, fucking cheater? Like, what am I doing here? I don't know. I don't really know. I just feel like sometimes like one day you just have like a switch that like turns on. You're just like, what the fuck am I doing here? But yeah, it's hard because like you'll have family members, you'll have friends that try to convince you. But like sometimes, you know, what they tell you, just ignore, right? It's like all within you. But yeah, I would say, but for me, I didn't really have like access to like therapy or anything like that. Or like, yeah, it was just something that I just like one day was just like, dude, what the fuck? Fuck this shit, you know? Dude, I was listening to this, oh my God, we should watch it, but I know we're watching this right now. I was watching this video about this woman who survived getting stabbed 30 plus times. Okay. The first stab was in her face. The guy literally fucking stabbed her in the face. And she was talking about how she was in this abusive relationship. She has kids with him. And literally, like, she started working. She was doing really well in her career. She was very happy. And then one day she was like, dude, what the fuck am I doing here? I'm fucking worth it. You know, like I'm doing really good. I'm happy generally. But what's bringing me down is this shitty fucking guy who's abusive towards me. I don't know. It's just like sometimes you just have that moment where you're just like, holy fucking shit. Like, what am I doing here? But yeah, it's tough. Like, especially with like, you know, strangers on the internet saying they're like, oh, you know, like you should leave the relationship. It's not your fault. Like that's all true. But it's hard because you'll have friends and family that'll say the same thing. And yeah, I don't know. It's tough.
And plaintiff's response to the motion, really when it's boiled down to the essence, what they really complain about is that the Laundries did not disclose Gabby's whereabouts. That seems to be the information that they really, that's really at the heart of their complaint. But what's interesting about the complaint is that they don't actually allege that the Laundries ever knew Gabby's whereabouts. As Mr. Melt said, it's insufficient for them to plead.
Oh, okay, sorry. Oh God, are we getting to the disgusting part of his argument? Hold on. Look at Gabby's parents. Sorry.
As they should to beat this cause of action. But the statement by the plaintiff's attorney that's alleged in paragraph 35 of the Second Amended Complaint,
Yep.
and plaintiff's response to the motion, really when it's boiled down to the essence, what they really complain about is that the Laundries did not disclose Gabby's whereabouts. That seems to be the information that they really, that's really at the heart of their complaint. But what's interesting about the complaint is that they don't actually allege that the Laundries ever knew Gabby's whereabouts. As Mr. Melt said, it's insufficient for them to plead opinions, theories, legal conclusions, or argument. The court does not have to accept those as true for purposes of deciding the motion to dismiss. The only allegation of any substance that the Laundries knew anything is at paragraph 20 of the Second Amended Complaint. And there it says, it is believed and therefore averred that on or about August 28th, 2021, Brian Laundrie advised his parents, Christopher and Roberta.
Oh, yeah, the love bombing. That's tough too, because the love bombing, it's like, oh my God, wait, the relationship can actually be like this? Because you're seeing the best side, right? And that's all you're hoping that you're going to get from the relationship. Yeah, the love bombing, that's a hard thing too. because you're like, this is the potential. This is how we could potentially be all the time if they weren't so angry all the time, if they weren't abusive, right? But yeah, you got to take someone at their worst, man.
That he had murdered Gabrielle Petito. They do not ever allege that Brian told his parents Gabby's location or any other details. And other than that one allegation, they don't allege any other conversations with Brian. They don't allege any conversations with Mr. Bertolino or some other source where they may have learned that information. They don't allege how, if the Laundries had that information, how they would have come to know it. For that reason, Your Honor, with respect to that issue, there are no allegations in the complaint other than conclusions or theories that the Laundries knew Gabby's whereabouts. And so if the plaintiffs don't even allege that the Laundries knew that fact, their cause of action can't be based on a failure to disclose it. Now, plaintiffs may try to argue that the Laundries' knowledge can be inferred from their other allegations. Your Honor, I would submit that that's not a reasonable inference. Again, first of all, they don't allege any other conversations with Brian Laundrie other than that one conversation. Second, as we know now,
Laura's like, do you know what he's talking about?
and as alleged in the complaint,
The guy's shaking his head.
Ms. Petito was found in a remote part of a national park in Wyoming. It's not a reasonable inference to assume that the Laundries would have known that location, or that they could have even found out where that was.
Brian could have told them, right?
Your Honor, intent is also a critical factor here, and one in which the plaintiffs offer no concrete allegations other than conclusions. I'll discuss intent again when addressing the plausibility of the allegations against the Laundries, but juxtaposing the intent required in order to commit this tort with the words of Mr. Bertolino's statement and the other allegations of the complaint, there simply is an outrageous conduct. The standard is, with regard to intent, that it's not enough that the defendant act with an intent which is even tortious or criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. And again, Your Honor, this is the Eastern Airlines case that I cited earlier. Rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Now, Your Honor, I did touch on our argument with regard to the paragraphs earlier, but I'll go through it in a little bit more detail here. So the first paragraph of Mr. Bertolino's statement acknowledges the difficulty of the situation for both families, which is important. It acknowledges what the plaintiffs were going through and the struggle that the Laundries were also balancing. Certainly a situation that neither family expected to be in and one that was full of challenges for everyone involved. Now, you couple that with the third paragraph, which basically says, I'm sorry, I know you would like us to say more, but we cannot on the advice of our attorney. We are going to stay in the back. The statement conveys, we understand how hard this is for you, but our son is in trouble, and we have to rely on the advice of our attorney in this extremely difficult circumstance. Far from being outrageous, that is exactly what most people in that situation would be thinking and doing. Those two paragraphs are critical because they run contrary to the plaintiff's conclusory allegation that the Laundries acted with malice and ill will. To the extent the Laundries withheld information with some sinister intent, which I'm not saying they did, that is facially disproved by Mr. Bertolino's statement that the Laundries will not provide additional comment based on the advice of counsel. Now, the plaintiffs want to focus on the middle paragraph, which is probably why they omitted the other two paragraphs from the complaint. Now, the first sentence of the middle paragraph says that a search was organized in Wyoming. A factually accurate statement. I don't think anybody is disputing that. The second sentence, which says, we hope the search is successful and Ms. Petito is reunited with her family. Now, the plaintiffs claim that that sentence caused them distress because it made it seem as though Ms. Petito could still be alive. Now, on its face, the statement does not indicate that Ms. Petito was or was not alive. It is an ambiguous general expression of hope. And we've cited a number of sources in our brief where the term reunited is used to describe when a deceased person's remains.
Oh, this is the worst. This is the worst, okay? When they say, oh, we hope Gabby Petito is reunited with her family, we're like, yeah, we're hoping that Gabby, alive, is reunited with her family, not Gabby, body, dead, reunited with her family. He's like, reunited could technically mean a dead person's remains. I mean, come on.
Remains are returned to family members. That's a term used by the National Institutes of Health, the Reuniting Families Project, the United States Army, and
look at their face. I'm there with you guys. I'm there
a number
with you
of
guys.
news organizations. Now, the plaintiffs dismiss this fact, but again, the plaintiff's subjective interpretation of the statement is not what controls. It's the objective interpretation. And those sources that I cited, government agencies and other news organizations, would use that word to describe when a deceased person's remains are returned to their family.
So you're saying from an objective
Yes, Judge. Ask the question.
standpoint, a reasonable, prudent person, if they are told, we hope that Ms. Petito is reunited with her family, that the reasonable, prudent person would believe that to objectively mean that her remains would be reunited?
Really, what I'm
In all instances?
I'm not saying.
Listen, Mr. Lawyer, you looking kind of foolish right at even the judge is calling you out. looking kind of foolish.
Yeah, I'm not saying in all instances, in all contexts. Really what I'm saying is that the statement is ambiguous. And so somebody reading that statement would not necessarily immediately jump to the conclusion she must be alive. And Your Honor, with respect.
Oh, dude, I don't believe in karma because my mom's boyfriend is still alive. Okay, that motherfucker's still living. I don't know how he's still living. He's still alive. I got all these friends, or they got great dads, uncles, dying of cancer and stuff like that. I'm like, bro, how is the evilest person I know in my fucking life so fucking alive? my siblings and I always joke about that. Evil never dies, bruh. Evil never fucking dies.
Back to the plaintiff's assertion that they interpreted Mr. Bertolino's statement to give false hope that Ms. Petito was alive, it's contradicted by the allegations of the Second Amendment complaint.
Okay.
So Mr. Bertolino made his statement on September 14th, 2021. And then 2 days later, the attorney for the Petito family, Richard Safford from New York, issued a statement to the Laundries, and it's found at paragraph 35 of the Second Amendment complaint. And I won't read the whole statement, but
Wait, is he answering the question, or is he just kind of like dodging right now?
specifically within that statement, Mr. Safford says, "We believe you know the location of where Brian left Gabby." And then later the statement says, "How can you keep her location hidden? Please, if you have any decency left, please tell us where Gabby is located."
Evil never dies. That is true. Yeah, alcoholic, smokes cigarettes, still fucking alive. What the fuck?
Now, the attorney asked 3 times in that statement about Ms. Petito's location.
But actually, I
But
don't know
not
if he
once
still
did he ask for
smokes.
clarification
Maybe he
about
quit.
whether or not Ms. Petito was alive. Clearly,
Oh, wait, hold on. I'm sorry. I'm talking over. All right.
how can you keep her location hidden? Please, if you have any decency left, please tell us where Gabby is located. Now, the attorney asked 3 times in that statement about Ms. Petito's location. But not once did he ask for clarification about whether or not Ms. Petito was alive.
Oh my God, this lawyer. When did he write this speech? The night before? Did you not think about this? Listen, sometimes when you're presenting your, I don't know, your emotions and stuff like that, or whatever it is that you're doing, maybe it might be a good idea for you to do it in front of your wife, your husband, kids, whatever. I don't know. Get their feedback. Like, hey, honey, how do you think this sounds? You're a normal average person, right? Do you think this sounds kind of outrageous or crazy? So they're asking, where's Gabby? Where's Gabby? Oh, but they didn't ask if she was alive or not. Well, if you're trying to get information from someone, you don't want to go the offensive and fucking attack them. You're not going to be like, are they alive? Tell me if he killed her. They're not going to go that because they still want information from them.
Clearly, at the time, the plaintiffs and their attorney did not believe that Mr. Bertolino's statement meant that Ms. Petito was still alive.
Okay. Yo, listen, I was, what was I doing yesterday when I was listening to this? I think I was feeding my dogs and I was like, what the fuck is going on over here? Jesus.
I think it's also important to note that this statement by the plaintiff's attorney focuses on Ms. Petito's location as the information that the plaintiff sought. But as
Oh, hey, Paul. How are you doing today? You're only 5'9", but I was like saying 5'10". 5'9"? What do you mean only 5'9"? Is that bad or something? 5'9" is fine. This is tough to listen to. I mean, it was okay listening to the other lawyer. This lawyer is like, he's being a little pedantic, but in really weird ways, man.
mentioned previously, there are no actual allegations as opposed to opinions or conclusions that the Laundries knew anything about Ms. Petito's location that they could disclose. Again, paragraph 20 only alleges that Brian informed his parents that he had murdered Ms. Petito, not the location. And in that same statement, Your Honor, by the plaintiff's attorney, he acknowledges the complicated situation faced by the...
He's like, this attorney right here, he's like, I can't wait to go up there. Also, I don't know any of these attorneys' names. I only know Stephen Bertolino. I don't know his name, and I don't know, I know his name's like Lucas or something? What's this guy's name? Robert De Niro?
Laundries. He says, we understand you are going
sitting
through a
right
difficult
there.
time, and your instinct to protect your son is strong. Again, Your Honor, conveying that they understood why the plaintiffs maybe couldn't say more. They recognized the situation, the difficult situation that everybody faced.
Right.
So again, that statement suggests that they were not insulted by their statement. They were not caused distress necessarily by the statement. They understood why the statement said what it did and why it didn't say other certain things. Your Honor, if we compare... didn't say other certain things.
This lawyer's like, well, I don't know, man. This guy looking like a clown right here. I don't fucking know.
Your Honor, if we compared the plaintiff's attorney's statement with Mr. Bertolino's statement, I don't think that we would say that the plaintiff's attorney's statement was tortious. The plaintiff's attorney expresses understanding for the Laundries' unenviable position, just like Mr. Bertolino did. And then, questions whether the Laundries had any decency left and things like that. And arguably, Your Honor, this statement was a violation of the rules of professional conduct because it was an attorney directly contacting a party who he knows to be represented by another attorney as opposed to going through that person's attorney. But regardless, Your Honor, the point is we could parse every public statement that an attorney makes and raise a cause of action for intentional infliction of emotional distress if that's what we're going to do in this case. This statement is not outrageous by Mr. Safford, and neither is Mr. Bertolino's statement. They're just public statements by attorneys during a very, very difficult situation for both families. Now, ultimately, the court has to decide whether Mr. Bertolino's statements were atrocious and utterly intolerable in a civilized community. And I would argue, Your Honor, if a statement by an attorney that's
Gabby's mom's like, yeah, pretty atrocious.
expressing sympathy, hope, condolence, trying to explain the difficult situation of his clients is utterly intolerable in a civilized community, then I believe we've lost our way as a society. Now, I don't did the plaintiffs allege another statement by Mr. Bertolino, Your Honor, in which he says the news about Gabby is heartbreaking. The Laundrie family prays for Gabby and her family. Your Honor, I don't think there's any context in which that statement could ever be outrageous. And regardless of whether the statement was outrageous, the complaint does not allege that Mr. Bertolino made that statement on behalf of the Laundries, as he did the September 14th statement, so it shouldn't be considered against them in any way. Now, Mr. Meltz touched on two cases that were probably the foundation of Judge Carroll's order. The first, Williams versus City of Mineola, and the site is that is 575 Southern 2nd, 683, and that's a 5th DCA case from 1991. Again, it's 575 Southern 2nd, 683. Your Honor, in that case, a 14-year-old died of an apparent drug overdose, but there was also an investigation as to whether or not foul play may have been involved. And the Orlando Sentinel published an article describing a party at one of the police officers' homes where they viewed the video and pictures of the autopsy of this young boy, where the audience were joking and laughing, mocking the pictures and whatnot. And now, the plaintiffs cite this case for the proposition that a grieving family is particularly vulnerable. And I would agree with that. That's what the case and the restatement, they do allow for that. But I believe the holding of Williams is a little more specific than that. Specifically, Williams said that a grieving family is especially sensitized to any disrespect or indignity directed at the decedent's body or representation.
Was he talking about the Kobe Bryant photos just now? Sorry, my sister was calling me. I was half listening.
Of it. The potential for severe emotional distress is enormously increased in that situation. Your Honor, in this case, Mr. Bertolino's statement did not direct any insulting or disrespectful comments against Ms. Petito, so it is distinguishable from City of Mineola in that regard. Your Honor, I would also
sorry, Mineola. That's the
comment
different
F
one.
of Section 46 of the Restatement of Torts, which is the section regarding vulnerable family members. It states the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if he did not know. And now, this is an important part, Your Honor. It must be emphasized again, however, that major outrage is essential to the tort, and the mere fact that the actor knows that the other will regard the conduct as insulting or will have his feelings hurt is not enough. Now, the City of Mineola case, while it supports the notion that grieving families are vulnerable, it does not say that any statement by an attorney for a suspect in a criminal case is per se outrageous, just because the attorney for the accused said it.
Gives me flashbacks of doing a book report in front of a class for a book I never read and hoping everyone believes it.
There must be major outrage. It is also important to note that the behavior in this case, the Mineola case, was by the police officers investigating the death. Now, those police officers held a unique position as to the victim's family, as the victim's family would be relying upon them to fulfill their investigative duties in a professional way. Your Honor, the other case, the Liberty Mutual Insurance Company versus Stedman case, which was cited in Judge Carroll's order. It was the primary case he relied upon for his determination that.
So this is the Laundrie's previous lawyer. I wonder if he's like, oh God, distance myself from this dude, please.
Context was important. In that case, Your Honor, the insurance company delayed paying for a double lung transplant for one of its insureds. A judge of compensation claims ordered the insurance company to pay for it. Despite that order, the insurance company ignored it and continued to delay with the intention that the plaintiff would die.
That's so fucked up. What insurance company is this? You guys hear that? So there's an insurance company that was supposed to pay for a double lung transplant, but the insurance company knew if the patient didn't get it, they would just die. So they kind of just held off for a little bit, hoping the patient would just fucking die and not fucking pay for it. Jesus. This is like an insurance company owned by like a mom and pop or something. Like, who the fuck would make this decision?
And so they wouldn't have to pay for the lung transplant. Now, again, Judge
I'm assuming the person died?
Carroll cited this case for
Liberty
the proposition
Mutual? Liberty Mutual? Oh, okay, I don't have Liberty Mutual. I heard of Liberty Mutual, though.
Context is important.
Jesus.
First of all, Your Honor, one important distinction is the insurance company had a duty to pay for the surgery. not only a contractual duty by the terms of their insurance policy, but they were also ordered by a judge to pay for it. And they ignored that duty in delaying paying for the surgery.
Because, okay, I'm assuming Liberty Mutual is like a big company, right? Like, who the fuck decides, like, hey, you know what? This is probably going to come out of my pocket, so I don't want it to come out of my pocket. Let's just wait a little bit. Like, that's... He said Liberty Mutual?
Now, Your Honor, I do disagree with Judge Carroll in this regard. The basis for his statement, or I'm sorry, the basis for his holding was that Mr. Bertolino's statement was, by all accounts, benign and not outrageous. But if the defendants knew something, or there was other context for the statement, then the statement could be outrageous. Your Honor, I would argue that if that were the case, that would impose a duty on the defendants to, if they spoke at all, to disclose something more than what they did. And that's not a duty that they had. For example, if a reporter asked Mr. Riley and I a question, and we withheld some information in response to the question, we're not legally obligated to provide a complete and total answer with all the information that we know about that subject. That's certainly not a duty the law would impose on us. And in fact, Your Honor, in that circumstance, we would probably run afoul of the attorney-client privilege if we disclosed everything we know about it.
Or could Judge Carroll's order rather mean that with the facts ultimately coming to light through discovery and otherwise, that this issue may be one that is better suited, this question may be one that's better suited for summary judgment or trial?
I think you're right, Your Honor. I mean, I do think that that's what he was getting at was, I'm going to give the plaintiffs an opportunity to see if they can develop some additional facts, and then I'll reconsider this issue at summary judgment.
I mean, but we're still at motion to dismiss, so we're still kind of at the same spot that he was at.
Yes, Your Honor, we are still very much at that same spot. Okay. Although, again, as I said, Your Honor, my feeling is that even if the plaintiffs had some other information that they didn't disclose in that statement, and that's uncovered in discovery, that doesn't mean that they had a duty to disclose it. That they aren't required to disclose everything they know every time they speak. That even in this context, Your Honor, Mr. Bertolino's statement was very clear that they were not going to say more based upon the advice of counsel. That's important context for it. That conveys that you may not like what we said here. It may not be enough. It may not be exactly what you would want us to say, but we have a right to rely on the advice of our attorney and not say more. That I think is an important distinction, Your Honor. Your Honor, another issue related with the Stedman case, I know that the plaintiff cited on the issue of unequal positions, which again is another subparagraph of Section 46 of the restatement. But Your Honor, my position is that that's really a red herring. So what the unequal position section of the restatement said, it's subsection E of 46. The extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with the other, which gives him actual or apparent authority over the other or power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable, even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. The extreme and outrageous nature of the conduct may arise not so much from what is done as from abuse by the defendant of some relation or position which gives the defendant actual or apparent power to damage the plaintiff's interests. The result is something very like extortion. Successful actions have been prosecuted in this context based on outrageously high pressure tactics of collection agencies, other creditors, and insurance adjusters seeking to force an unfair settlement. And Your Honor, that's cited from Dependable Life Insurance Company versus Harris. That's 510 Southern 2nd, 985, specifically page 988, and that's the 5th DCA case from 1987. So, Your Honor, somebody involved in a criminal investigation making a public comment is not really what's intended by this subsection. The conduct must be something like extortion, where the person abuses their authority to extract something from the other person, and that's really not what we have here. Your Honor, I mentioned intent earlier, and the plaintiffs have alleged that the Laundries maliciously and willfully inflicted emotional distress. Now, in both of these cases that I just discussed, the intent is fairly clear. The Williams police officers who were supposed to be investigating the victim's case openly mocked and joked about his death during a party. By all objective measures, very unprofessional, and done with the intent to mock the deceased, to make fun of him.
Okay.
And, Your Honor, just like Judge Carroll mentioned, duty is important in this context. And you could say that police officers have a duty, or at least an expectation, to be professional with victims and their families. Now, in the Stedman case, the insurance company clearly acted with the intent to disregard the judicial order, and with the hope that the plaintiff would die. The insurance company clearly acted with ill intent. Now, nothing about Mr. Bertolino's state comes close to that level of callousness. Nor did he have a duty to say more than he did. And other than general recitations of intent, the complaint has no specific factual allegation.
I do want to remind you, like almost about a year ago, the previous judge did a motion to dismiss because the defendants, they wanted to have this entire thing dismissed against them. The judge was like, nope, we're going to continue on.
Demonstrating that the Laundries or Mr. Bertolino harbored an intent to act outrageously or to...
So I don't know if he's like still making the same arguments or if he's bringing new arguments, but the other judge already ruled. So I don't know. I don't know if this judge is like what are we talking about here?
do harm, which they're required to have. Rather, Your Honor, again, if you look at that first paragraph of the statement and the last paragraph of the statement, the first paragraph being that we're really sorry about this, but it's difficult for both families. We know you're going through something difficult, but we are too. And then the last paragraph where he says, I'm sorry, we can't say more based on my advice as an attorney. Now, the plaintiffs acknowledge that their cause of action on these facts is novel. And it is novel because Mr. Bertolino's statement is not outrageous. Everyone involved in this tragic saga had rights that protected them. And those rights may have worked to the detriment of others. But the exercise of those rights is not objectively outrageous. We can all imagine where the exercise of rights may be subjectively outrageous to the person who is disadvantaged by the exercise. But objectively, the law must protect the exercise of rights. Now, this leads me to my next argument, Your Honor, which is that Mr. Bertolino's statement was legally protected. There's two ways in which it was protected. The first, the privilege to do what is legal.
Yeah, so he's bringing up these two cases because I don't know who brought it up first, but the previous judge, when they denied the defendant's motion to dismiss, the previous judge did talk about these two cases, the one with the hospital and the one with the cops showing autopsy photos at a party. And the judge basically said that the defense, they're missing the mark when they're referring back to these cases, and that it actually supports the court's decision to dismiss the defendant's motion.
Legally permissible, and second, the litigation privilege.
I covered in the
So
video
for the
that I
first
posted
recognition
yesterday.
of the tort of intentional
Watch
infliction
that
of
one.
emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would be otherwise be extreme and outrageous, may be privileged under the circumstances. The actor is never liable, for example, where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. And Your Honor, that's the Metropolitan Life Insurance Company case, which I cited earlier.
Oh, Metropolitan Life Insurance. Metropolitan. What life insurance did you guys say? Liberty Mutual. I don't think you're even close. Hold on a second. You guys are over here defaming Liberty Mutual. Metropolitan Life Insurance. Hold on. Let me look it up. I literally have it right here. Oh, wait. No, I'm just kidding. Sorry. He cited Mineola, but sorry. I'm thinking about something else. There's another one where the judge brings up the case that there's a family member that went through surgery. The hospital decided to do a cover-up and said that like they died from stress of surgery, not by the negligent overdose of a drug during surgery. And then when the medical examiner found out, they were like, wait a second. We need the body back because, they're about to do the funeral thing. They were like, I need the body back and we need to do a complete autopsy because we need to expose the hospital. Sorry, that's a different one.
467, Southern 2nd, 277, Florida Supreme Court, 1985. And this principle has been upheld many times since, and we cite to some of those cases in our brief. Now, as an initial matter, our first motion to dismiss discussed a number of rights that protected the Laundries from having to say anything. And as Mr. Bertolino put it in his statement, they could remain in the background. That was their legal right. And
Okay.
Judge Carroll summed up that finding that the Laundries had no duty to do anything,
Yep,
even if the plaintiffs
did.
wanted them to do more.
Yeah.
As I discussed, I disagree with
Yeah. They had a right to stay silent. They had a right to not say anything.
Judge Carroll with regard as to whether or not that duty should be extended to whether they needed to say more in the statement, in Mr. Bertolino's statement. I would argue that the law doesn't impose a duty on them to say more than what they did. Now, as it relates to Mr. Bertolino's statement more specifically, there is an additional way in which he was exercising his professional obligation in a permissible way. ABA Model Rule of Professional Conduct 3.6 permits an attorney to make a statement to protect his client from adverse publicity. Specifically, that rule says, notwithstanding paragraph A lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. And again, that's ABA Model Rule of Professional Conduct 3.6, subsection C. Now, plaintiffs argue in their response that there are not enough facts within the second amended complaint to infer that Mr. Bertolino's statement was made under these circumstances covered by the rule. Your Honor, I would disagree. So, first of all, the plaintiffs allege that Brian Laundrie murdered Gabby Petito. That's at paragraph 16. They reference the search in Wyoming, paragraph 28. They allege that the Laundries and Mr. Bertolino were assisting Brian to flee the country. Again, we vehemently oppose that, but they allege it. They specifically set forth at least 3 public statements by attorneys that were published to the media for both families. It's paragraph 31, 35, and 38. They allege Mr. Bertolino's September 14th statement
ABA stands for American Bar Association, by the way.
was intended to be disseminated nationwide and was broadcast in news reports in Florida and nationwide. Again, paragraph 31. They also allege that Mr.
At this
Bertolino
point,
released...
Yes, at this point, they have read the letter. Everyone's read the letter. They just want a copy of the letter. Later on, they're going to argue about the letter.
I'm quoting, numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and Brian Laundrie to the national press, paragraph 33. And they allege that Mr. Bertolino gave a televised interview in October of that year, paragraph 27. There are enough allegations to support that there was media
She said he did.
attention on the case. Now, the rule itself does not require a certain level of publicity that the attorney is responding
Wait,
to.
what?
Now, the rule itself does not allegations to support the televised interview in October of that year, paragraph 27. There are enough allegations to support that there was media attention on the case.
Okay.
Now, the rule itself does not require a certain level of publicity that the attorney is responding to. It just says recent publicity. It could be a response to one article about the case, but certainly the plaintiffs have alleged enough in here, enough in their second amended complaint to support that there was publicity on the case that Mr. Bertolino could be responding to. Regardless of whether the facts of the second amended complaint fit neatly into the model rule, the standard is whether Mr. Bertolino and the Laundries were insisting on their legal rights in a permissible way. Even if every element of Model Rule 3.6c is not satisfied by the allegations of the complaint, the mere existence of the rule demonstrates that Mr. Bertolino had a good faith basis and legal right to make the statement. Now, plaintiffs argue in their response that if Mr. Bertolino was issuing a statement to protect his clients, he would have given what the plaintiffs wanted, which was Gabby's location. First, the rule does not specify what kind of statement an attorney must make. Second, such an argument would impose a duty on the defendants too, if they spoke at all, to disclose everything, which again, we don't believe the law imposes that duty. And then third, Your Honor, the statement Mr. Bertolino gave, while not satisfying to everyone, was the best he could do under the circumstances. It acknowledged the plaintiff's grief, while also informing them that the Laundries could not say more based upon the advice of counsel. Now, Your Honor, I'll turn to the litigation privilege.
Before you do that, with the ABA model rule, what would provide that as being legally permissible?
Well, Your Honor,
he's not a member of the. I mean, he's a member of the New York bar.
Right? Exactly, Your Honor. Yes.
So, and he was making allegedly those statements in Florida. So, are those model rules are intended to be adopted?
Yeah. Again, I also wonder, why did they reach out to a lawyer all the way in New York? Was it like a referral or something like that? Why not get a Florida lawyer? Just curious.
Associations. So I mean, I don't know that we have one in Florida bar that.
Your Honor, you're right. I don't know that we do. Although I would say I don't believe Mr. Bertolino made the statement in Florida. I believe he may have made it in New York or someplace else. Obviously,
he's not governed by the Florida bar.
Exactly, Your Honor. He is
So
not.
I mean, I guess that's the. I mean, the
Didn't you know this?
ABA model rule. Those are just what they say. Model rules. We have model rules and laws nationwide. That doesn't mean that they're actually laws we have to follow.
No, you're right, Your Honor. And it's not so
Okay.
much that it's a law that he would be required to follow.
Okay.
But what it is a recognition that an attorney can make a statement like this, a public statement like this, and not run afoul of rules of professional conduct. It is a permissible rule, not so much a rule that seeks to.
But it's not a permissible rule in the state of Florida.
I agree with you,
Okay,
Your
all
Honor.
right.
Yes, it's not a permissible rule in the state of Florida. Yes, I would agree with that
I
point.
just wanted to make sure that there wasn't something similar in New York, or that you were going off.
I don't know about New York, Your Honor. I do know that in Florida, I don't believe that rule is part of our rules of professional conduct.
Doesn't that kind of just undoes his
I'll bring it up.
argument?
I'm just going to address it while we're taking a short break.
Undoes? Yeah, drink that water. Drink that water.
Necessity that certain persons, namely attorneys in this context, because of their special position or status, should be as free as possible from fear that actions in that position might have an adverse effect upon their own personal interests, which is really what we have here. To accomplish this, it is necessary for them to be protected, not only from civil liability, but also from danger of even an unsuccessful action. Now, Your Honor, while that's important to my clients, is that if a principal's liability rests solely on the doctrine of respondeat superior, a principal cannot be held liable if the agent is exonerated. So if Mr. Bertolino can invoke the litigation privilege, then my clients cannot be legally responsible for whatever conduct he did that caused the invocation of that privilege. Now, Florida has recognized both absolute immunity and qualified immunity in the litigation privilege context.
Aw, congratulations to your son. Have fun.
Now, typically, the absolute immunity is afforded to statements made in the course of judicial proceedings or trials.
Eichmel? Who's that?
But it also includes proceedings before a competent court or magistrate in the due course of law, or the administration of justice, which is to result in any determination or action by such court or officer. This privilege extends to the protection of the judge, parties, counsel, and witnesses, and arises immediately.
Wait, okay, I Googled Eichmel letter. Eichmel is a sex trafficking code word. Wait, what? What is this? You have a link to it? Can you post it in my Discord?
Upon the doing of any act required or permitted by law in the due course of the judicial proceedings, and then here's the important part, or as necessarily preliminary thereto. And that, Your Honor, that's Fritovich versus Fritovich. That's 598 Southern 2nd, 65, Florida Supreme Court, 1992. And that's citing another Supreme Court, Ainge, for that same proposition. Now, Your Honor.
Wait, sorry. Let's cut through this really quick. Is it this video?
I love you, son. I'll always be here. If you need to kill someone, I'll support you. I'll help you get rid of the body.
Wow, if you read it in that tone, that's definitely creepy.
As we pointed out in our brief, the Florida Supreme Court has not addressed whether absolute or qualified immunity would extend to a lawyer's comments in a situation like this. As the plaintiff's cause of action is novel, so is our request to extend the litigation privilege in response to it. Now, the Florida Supreme Court has extended the absolute privilege in certain pre-litigation contexts, specifically the Ainge case that I referenced. It's Ainge versus State, 123 Southern 9. It's an old case, Southern 916, and that's from Florida, 1929. And in that case, Your Honor, the court found
what's
that
your counter raise his lawyer up
the
to
absolute
now?
privilege barred an action for defamation based on statements made in the office of a county judge to whom the defendant had gone to obtain a warrant. Your Honor, also Robertson versus Industrial Insurance Company, that's 75 Southern 2nd, 198. That's Florida Supreme Court, 1954. Absolute privilege applied to defamatory statements made in a letter to the insurance commissioner used to initiate license revocation proceedings.
Give me the last the page number for the Ainge.
Sure. So
123
123 Southern 916.
Thank you. Perfect.
Now, the Florida Supreme Court has also recognized
Nelly.
a qualified privilege rather than an absolute privilege in the context of statements made to police in a criminal investigation prior to the initiation of criminal proceedings, and that was the Frutovich case that I cited to you earlier. Also in Delmonico versus Traynor, the site for that is 116 Southern 3rd, 1205, Florida Supreme Court, 2013. And in that case, Your Honor, the Supreme Court extended the qualified privilege to statements made by an attorney as they undertook an informal investigation and interviewing witnesses. So now, Your Honor, we acknowledge that this case does not fit neatly into any of these examples, and we would be asking the court to extend the privilege to the context where an attorney makes a public statement in the face of a criminal investigation of one of his clients. But again, Your Honor, relying on Model Rule 3.6, there is a basis for doing so. If rules of professional conduct contemplate an attorney making a statement, or even compelling such a statement to fulfill a duty to defend his client, then there is no reason that such a statement should not at least be protected by a qualified privilege. We can all think of countless examples where an attorney for a defendant makes a public declaration of innocence, or a prosecutor makes a public declaration of guilt before the case is decided. And now every one of those cases should not trigger a civil action for intentional infliction of emotional distress if the case turns out differently than those proclamations. Your Honor, the basis for whether an absolute or qualified privilege, the basis of such a privilege is for lawyers is to permit a free adversarial atmosphere to flourish, which atmosphere is so essential to our system of justice. That's Sussman versus Damien, 355 Southern 2nd, 809, Florida, 3rd DCA, 1977. In fulfilling their obligations to their clients and to the court, it is essential that lawyers, subject only to control by the trial court and the bar, should be free to act on their own best judgment in prosecuting or defending a lawsuit without fear of later having to defend a civil action for something said or written during the litigation. A contrary rule might very well deter counsel from saying or writing anything controversial for fear of antagonizing someone involved in the case and thus courting a lawsuit, as a result of which would seriously hamper the cause of justice. And again, Your Honor, that's a quote from the Sussman case. Your Honor, it is an important point that Mr. Bertolino is an officer of the court, and subject to the court's jurisdiction and also regulation by his bar association. And if he truly did step out of line, he is subject to control by those entities. His clients and him also should not face a civil action merely because of his comments about an ongoing public investigation. Now, plaintiff's response discusses the case of Ball versus D-Lights Enterprises, Inc. The site for that case is 65 Southern 3rd, 6.
Jesus, he goes over an hour? How long was the first lawyer? 24. First lawyer. First lawyer went for like 30, 40 minutes. Bro, this guy goes for over an hour.
37. It's a 4th DCA case from 2011. And Your Honor, all these cases I'm citing should be in the binders, citing and everything.
1/95.
Yeah.
And I don't want to cut you off, but I've given both of you, like, at this point, 45 minutes for Mr. Metz and 45 minutes close to 45 minutes for you, and I just want to make sure that
Understood, Your Honor.
He's at an hour right now. He's at an
I
hour.
will move more quickly.
He going for
I will
another
move more
20
quickly.
minutes.
So, Your Honor, in the Ball case, in that case, a party to a lawsuit published some disparaging remarks on their own commercial website about their opponent's business practices. Now, I can understand in that context why the litigation privilege would not cover it, because it was essentially a party to litigation disparaging a business competitor in a commercial context, entirely commercial context, and it just happened that the two entities were also engaged in litigation. This context is different, Your Honor. The statement is made by an attorney. And there is a rule of professional conduct that permits that statement. That type of statement is much more closely aligned with the litigation privilege than is the statement by a private entity on their website in a commercial business context.
Say, hurry the hell
At
up.
what stage are these cases that you're citing getting resolved? Are they getting resolved in a motion to dismiss stature? Or
Some of them, yes, Your Honor. Although I would submit, Your Honor.
I will look through them.
Yes, the litigation privilege probably is something that requires more factual development in certain contexts. I mean, now there may be cases where it's very obvious from the four corners of the complaint that there was a case that was initiated. I'm sure the court could take judicial notice of certain things. If a case had been filed, if a case related, and things like that. So that's obviously not the context we have here.
Right.
Judge is like, man, I got some homework to do.
I do agree with you on that. I do agree with you on that. Your Honor, Mr. Meltz covered causation. I'll just touch on it briefly here. So the Florida Standard Jury Instruction 410.6, which is the intentional infliction of emotional distress in jury instruction, says that extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. Now, the jury instruction does allow for concurring causes, but again, even a concurring cause must contribute substantially to producing the distress. Now, I don't think the plaintiffs dispute that there were concurrent causes, that they were already suffering severe distress prior to Mr. Bertolino's statement, even after Mr. Bertolino's statement, that was not necessarily due to anything that Mr. Bertolino said. But, Your Honor, really what is critical here is the word producing, or substantially producing. Because as Mr. Metz pointed out, paragraph 35 of the complaint, within the statement by the plaintiff's attorney, Richard Saffold, he said, we haven't been able to sleep or eat, and our lives are falling apart. Again, not caused by Mr. Bertolino's statement, just caused by the circumstances.
Okay, the other already said this.
And also the way that the plaintiffs have alleged causation in this case is interesting.
No,
They say that the defendants could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and the location of the remains of Gabrielle Petito. It's paragraph 39. Failing to prevent mental suffering that is already occurring is not the same as producing it. The distress has already been produced. It's ongoing. And really what the plaintiffs are arguing is that the Laundries failed to stop it.
The other lawyer already said this.
Again, I think it's also important to point out that they allege the Laundries caused their emotional distress by not disclosing what they knew about the well-being and location of the remains of Gabby. And as Judge Carroll found, disclosure is not a duty they had. And it was also, Gabby's location is not a fact that the Second Amendment complaint alleges the Laundries knew specifically. But what we are dealing with specifically here, Your Honor, is whether Mr. Bertolino's statement produced their distress. But they don't allege that the statement produced distress. They allege that what was not in the statement caused them to suffer continued distress, which again is not the same as producing. Your Honor, Mr. Meltz also touched on this, so I won't spend too much time on it, but for conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff and in his or her presence. And that's Dunkel versus Hedman, cases 2016, Westlaw 487-0502. That's a Middle District of Florida federal case from 2016. We cite a number of other cases, Your Honor. I'm not going to do that now. They're in the brief.
Please don't,
that
please
same
don't.
proposition.
Yes, please
Now,
don't.
in their response, Your Honor, the plaintiffs, in arguing against the application of the litigation privilege, which is at page 24, paragraph 55 of their response, they acknowledge this fact. They say, furthermore, the statements made by Mr. Bertolino were not made to anyone involved in any potential court proceeding. So the plaintiffs are correct. Mr. Bertolino's statements were not directed at the plaintiffs or anybody in any potential court proceeding. And as a result, they don't have a cause of action for intentional infliction of emotional distress. Now, Your Honor, my final argument, my plausibility argument.
Wait, what? I thought you would have to report it, like especially if you're in the same household. Are you talking about like if you're like someone's neighbor?
As I mentioned earlier, it's not sufficient for the plaintiffs to plead opinions, theories, legal conclusions, or argument.
I don't know. I
the
don't
court
think
does
you would
not
have to
accept those as
report
true.
it.
Now, the two cases that set the minimum standards for federal pleading, which Florida courts have expressed acceptance for, are Bell Atlantic versus Twombly and Ashcroft versus Iqbal. Now, Your Honor, I would submit that this complaint is full of opinions, theories, legal conclusions, and argument. As mentioned earlier, there was only one allegation of a conversation between Brian and his parents in the whole entire complaint. And even that allegation begins with the phrase, "it is believed." There are no allegations that the Laundries learned any other information than that one allegation. Now, I want to focus on the allegations regarding the state of mind. And now, specifically...
Maybe it depends on the state. Not reporting a dead body is a crime in Texas. Failure to report a dead body. What does this say? Oh, God, it's so long.
They allege that Mr. Bertolino's statement was outrageous and that all three of the defendants, acted willfully and with malice in issuing it. Now, plausibility means that once the complaint has been whittled down to its non-conclusory allegations, the court undertakes the second step of determining whether the complaint states a plausible claim for relief. The plausibility standard asks for more than a sheer possibility the defendant
Yeah, I think it depends on the state.
has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. Now again, the plaintiffs have alleged that each defendant individually acted willfully and maliciously toward the plaintiffs. Now, it doesn't allege a conspiracy or some other agreement amongst the defendants. It doesn't allege that any of the defendants forced another one of them to do something. The complaint doesn't even allege that Mr. Bertolino and the Laundries ever spoke about the statement before it was issued. It alleges all three independently had that heightened mental state to inflict severe emotional distress. Now, the plaintiffs have to advance that theory because this is an intentional tort. This isn't a negligence action where the Laundries are liable for Mr. Bertolino's negligence simply by employing him. Likewise, Mr. Bertolino is the one who made the statement. So he can't be liable if he didn't have the intent.
Oh, you're talking about the twins. Or not twins. They're like a year apart, right? Oh my God, that was such a sad case. I don't know. I think in California it says you have to report if there's a dead body. I mean, if you're like one of the siblings, yeah, you're probably not gonna get in trouble because overall you probably have abusive parents. Yeah, they were both found guilty, right?
Harm. But that dictomy creates an implausible scenario. If Mr. Bertolino, as plaintiffs alleged, harbored such malice toward the plaintiffs to intentionally inflict emotional distress, to deliberately commit an act that goes beyond all bounds of decency, he would have been acting for himself, not as an agent, as an attorney for the Laundries. If Mr. Bertolino allegedly committed an intentional tort for his own purposes and not on behalf of his clients, then his clients cannot be liable for the acts of their agent, and the Laundries should be dismissed. And we cite the Diaz versus Associated Loan Company. It's 99 Southern 2nd, 279, Florida, 1957, which says the liability of the master for intentional tort acts which constitute legal wrongs can only arise when that which is done is within the real or apparent scope of the master's business. It does not arise where the servant has stepped aside from his employment to commit a tort which the master neither directed in fact nor could have supposed from the nature of his employment to have authorized or expected the servant to do. If Mr. Bertolino harbored the mental state necessary to commit something so...
Josiah West, Trezel's younger brother, then took the stand. He also testified saying he did not see the boys at any point after Trezel and Jacqueline moved to California City in September. I don't know, that's all I got here.
Egregious, he could not at the same time fulfill his role as an attorney to the Laundries. It's hard to imagine a scenario where an attorney could commit an intentional tort and still be acting in his professional duty to his client. Making a statement that is utterly intolerable in a civilized society wouldn't be serving any client's interest. And if Mr. Bertolino, as the Laundries attorney, advised or even permitted his clients to issue a statement based on his own maliciousness, as the plaintiffs have alleged, then the Laundries could not have had the mental state necessary to commit the tort. They would have simply been allowing their attorney to act as their advocate, something that is not outrageous or to be regarded as atrocious and utterly intolerable. Now, if there is an obvious alternative explanation...
Person who fails to make a required report is... Oh, jeez, blah, blah, blah. Is guilty of a misdemeanor punishable up to 6 months in jail. Failing to report. Or up to $1,000 fine. Maybe they didn't have enough evidence. Maybe they didn't have evidence. Maybe they didn't have enough evidence against him for that.
Explanation for the Laundries' activities. The court can choose the more plausible conclusion. Where the conduct is more likely explained by lawful behavior, the complaint does not plausibly allege a claim for relief. The most obvious alternative explanation is that this was a very upsetting time.
All right, you guys are going to put me on the FBI watch list with all these Google searches.
For everyone. And Mr. Bertolino was simply trying to express that without doing any harm to his clients. As his statement said, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Now, Your Honor, in conclusion, the
We're
plaintiff's pain
here.
and frustration with how the investigation into Gabby's disappearance occurred is understandable. Absolutely. We all have sympathy for them. But as judges and lawyers...
But do you have sympathy? Do you?
We know that almost every case, criminal or civil, involves some pain and frustration for the parties involved. Now, most of the time, not to the level of losing a child. But
Like, here's what I want to know. What I want to know is, do lawyers, is it expected for them to make arguments that even sound outrageous because they're just hoping, you know, whatever sticks might stick? I thought that might be true if you're like arguing to a jury, because you never know what arguments a jury might like and not like, right? But when you're making these arguments for motions to a judge, right? I don't know. aren't there some arguments you kind of want to be careful not to present? Like for him saying that, like, oh, well, technically unite could mean the remains of Gabby, Gabby's remains reuniting with her family. And then he also mentioned the, when the Petito family kept asking where Gabby was. Well, they weren't asking if she was dead. It's like, I could understand you making this argument to a jury because, maybe to a jury, you never know which one of the 7, 9, whatever, might be like, oh yeah, this guy's right. But making to a judge? Well, shouldn't you? I don't know. I am curious. I am curious. Like with the strategy, shouldn't you change your strategy a little bit?
There is some discomfort.
What do I do?
As humans, we have yet to craft a perfect system where everyone is protected. The victim, the accused, their families, but...
Because sometimes we do see lawyers reaching at straws when they're presenting, right, in front of a jury. But like, I don't know, like his arguments today in front of a judge, it seems kind of like a little wonky, bruh.
That would be impossible because everyone has rights. And often those rights butt up against each other. For that
Like,
reason,
I wonder, what do they
legal...
teach in law school? Yeah, shit. Yeah, I want to know, what do they teach in law school? That's what I want to know.
Guardrails to keep everyone involved in an investigation from being sued every time. While the plaintiffs deserve our sympathy, they just don't have a case against the Laundries. Thank you, Your Honor.
Because, yeah, they're playing devil's advocate, but...
We've been going for about 2 hours. Would anybody...
This judge. We've been going on for 2 hours. Like, oh my God. Okay, I'm gonna use the bathroom really quick, guys. Get up, stretch, and we're gonna listen to Petito's lawyer. Finally! Next, Petito Schmidt's lawyer. Bathroom. Ooh, okay, we're almost there. Letitia's attorneys. Man, I don't know. I could tell they did not want to represent her. I hope she's still constipated. Is he trying to play online solitaire? I hate solitaire. Hi, Ricta. How are you doing today? I know they teach you not to lie and cover it for your clients. Okay. Kim K passed the baby bar exams. Makes you question what they're actually teaching in law school. Who? Kim Kardashian? Is that what you're talking about? Kim Kardashian took it 6 times and had a team of lawyers tutoring an Adderall. Wait, who? Are we talking Kim Kardashian?
Be objectionable to like a 5-minute break?
I would love a short break.
Okay, let's do that.
All right, I listened to this guy in 2 times speed. He was a lot easier to listen to.
Most all of the issues that have been raised out of
Okay.
this won't take 2 hours.
With plaintiff's argument, Ms. Riley.
All right, Petito Schmidt lawyer
I
coming up.
would, Your Honor. I promise I won't take 2 hours. May it please the court. I think if Judge Carroll were here today, the first words out of his mouth would be, didn't I already decide these issues? Most all of the issues that have been raised here today have already been decided by Judge Carroll in a
I love it. Coming in with the spice.
very well-reasoned decision. The plaintiffs, or the defendants in this case, are simply looking at another bite at the apple to try to argue the same issues and hoping that you, as being
Another
relatively
bite
new
takes
to the
the
case,
dust.
will overrule what Judge Carroll previously ruled. There's been no new evidence that they've submitted, no new arguments that they've made that would make any difference. And for them to suggest that Judge Carroll didn't consider some of the elements of a cause of action of intentional infliction of emotional distress when he rendered his opinion is frankly insulting to Judge Carroll.
Oof.
The only
Oh my God, this guy. It's pretty much directed at this guy.
change that occurred in this case
Okay.
with between the First Amendment complaint and the Second
Hi,
Amendment complaint
Gwen.
is that Attorney Bertolino was named as a defendant. There were some jurisdictional allegations that were included, and there was a second article that was included. But beyond that, the bulk of the complaint, the majority of the complaint, the structure of the complaint has been ruled on in a motion to dismiss before Judge Carroll, and he found that it was sufficient to move forward. This case is not based upon silence. We're not arguing that the Bertolino, that the Laundrie's refusal to provide information regarding Gabby.
I had to let Mini Clerk in.
Okay.
So we should be okay. She's listening in her spots.
All right.
So getting them also this side.
We're not arguing that the fact that they kept quiet about whether Gabby was living or wasn't and where her body was located is the subject of this cause of action. It's not. This is about the statement that was issued by Mr. Bertolino on September 14 of 2021.
Down.
Issued with the knowledge that Gabby Petito was deceased. Issued with the knowledge, and we did suggest in the complaint of paragraph 28, that they knew where Gabby Petito's body was located. With that knowledge, and knowing that Joe Petito and Nicole Schmidt were desperately searching for any information about their daughter, they issued a statement. And by the way, when that statement was issued, counsel, Mr. Meltzer, suggested that Mr. Bertolino was simply the attorney for the Laundries. He was more than that. He was also their spokesperson. He did all their speaking for them, whether it was
Yeah, I was calling him De Niro earlier. Lion De Niro.
related to a legal representation or not. He did all of the speaking for them. The statement that was issued on September 14, there's 3 paragraphs. The first paragraph says it's a difficult time for the families. It's a meaningless paragraph in terms of this litigation. The third paragraph says there will be no more statements issued, or that Laundries won't speak. Nothing to do with the crux of that statement, which is the subject of this cause of action. And that statement is, it is our, and I highlight our, understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our, and again, I emphasize our, hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. Counsel has suggested that this statement wasn't directed towards the Petito family specifically. But who else, if it wasn't directed to them, was it directed to? What was the purpose of the statement? What reason would there be to make that statement other than to express the hope?
Obviously directing it towards the Petito, but at the same time, wanted to give a little bit of something to the public because the public was giving them pressure. And so they probably just wanted to put out a, general statement, whatever, just to ease all the scrutiny, even though it wasn't going to do shit because they weren't releasing anything. They weren't saying anything, right? Just some bullshit statement. Damn, and now they're getting in trouble for the bullshit statement.
The Petito family, that she would be located. Who else would they be expressing the hope to? Mr. Bertolino's suggestion that the statement was issued only on behalf of the Laundries is belied by his own language in that statement where he says our on multiple occasions.
Yikes. Yeah, because Bertolino's like, okay, well, I was only speaking on behalf of my clients. Like, well, you're getting roped into this as well.
The defendants want you to take that statement and read it entirely out of context. They want you to believe that it was the sincere expression on the part of the Laundrie family and Mr. Bertolino that they hoped that she would be found. And if you looked at it in that context alone, arguably, I would agree. It is harmless. It could sound like a heartfelt expression of a true desire that they hope that Gabby Petito was located.
Right.
But
Context matters.
when taken in context and looking at all of the allegations in the complaint, it suggests that they knew when that statement was made that Gabby was deceased, that they knew where her body was located, and they knew the family was grieving. Mr. Meltz did a good job of cherry-picking portions of the complaint and taking them out of context, but let's put it in context.
Damn.
In July, and these are all allegations that are in the complaint.
Don't ever get an argument with Daddy De Niro. Holy shit. He's I like his very effective.
July 2nd of 2021, Gabby and Brian embark on a Western U.S. journey in Gabby's van, paragraph 10 of the complaint. Gabby called her family almost daily, paragraph 13. There was no contact with Nicole Schmidt after August 27, 2021. No contact with Joseph Petito after August 21 of 2021. That's paragraphs 14 and 15 of the complaint. The paragraph 16 says, there's a belief that Brian murdered Gabby on August 27 of 2021, and the cause of death was blunt force injuries to the head and neck with manual strangulation. Paragraph 16. On August 28th.
That's crazy because I didn't see the Whole Foods footage until recently, but there's a Whole Foods footage of them going to Whole Foods, walking down the aisles and stuff, and this is either the day of the murder or the day before the murder. Ah, God, it's always so... it's always so like I don't know, like my hairs are just like when you see like the last footage of someone before they're gone forever.
Brian Laundrie contacted his parents. On August 29, his parents contacted Attorney Bertolino, and a retainer was sent to Attorney Bertolino on September 2 of 2021. That's paragraph 20.
So at this point, they must have like phone records at this point. That's what I'm assuming.
September 1, Ryan returns home in Gabby's van without Gabby, paragraph 22. On September 6th of 2021 through September 7, 2021, the Laundries go on vacation with Brian while Gabby is missing, paragraph 25. September 14, Mr. Bertolino issues a statement that I just read a moment ago. And again, as I said, paragraph 28 does indicate we believed that at the time it was issued that they knew the whereabouts of Gabby Petito's body. He also issued a statement on October 23rd of 2021 in which he said when Brian Laundrie left his home on, I believe it was the 13th of September, he was grieving. Definition of grieving is feeling sad because someone has died. On September 19 of 2021, Gabby's remains are located, and Mr. Bertolino issued another statement The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. Her death wasn't news to the Laundries or Mr. Bertolino. They knew she passed away. The only news to them was that Gabby had finally been found. Putting Mr. Bertolino's statement in context, as Judge Carroll noted in his opinion on the prior motion to dismiss, if the Laundries and Bertolino knew that Gabby was dead, knew the location of her body, and knew her parents were frantically looking for her, the statement was particularly callous and cruel and is sufficiently outrageous to state claims for intentional infliction of emotional distress. That hasn't changed.
Yeah, pretty fucked up.
None of that has changed by the filing of the Second Amendment complaint. As the court knows, the motion to dismiss must be...
Quick question. Brian Laundrie, does he have siblings? Or is he the only child? If he does have siblings, particularly younger siblings, or maybe siblings, because he's young too. He was like, what, 22, 23? Damn. What example is the parent setting for their other fucking kids? If they have other kids. I don't know if they do or not. Cousins, family members. I don't know, dude. That's such a bad example. Oh, he has a sister? Oh, older sister? Yeah. Oh, I don't know. Like, I get it. Like, ride or die. I'm here for you no matter what. But, bro, man, if you're a fucking kid, commits murder, I don't know, man.
Confined to the four corners of the complaint. You have to accept as true the plaintiff's allegations and draw every reasonable inference from those allegations in favor of the plaintiff. Defendants have taken liberty in their motions, as I have indicated in my brief, by bringing facts in that are not a part of the four corners within the four corners of the complaint. I'll discuss that.
Oof.
As was noted, intentional infliction of emotional distress became recognized as a cause of action by the Florida Supreme Court in 1985 in the Metropolitan Life Insurance case.
Okay.
And the Supreme Court adopted Restatement of Torts Second, Section 46, which sets forth the requirements necessary to prove a intentional infliction of emotional distress. They are deliberate or reckless, not intentional, deliberate or reckless infliction of mental...
Wait, deliberate? What will be the difference between deliberate and intentional? Or just being nitpicky here? Isn't that the same thing? Deliberate, done consciously, done consciously and intentionally. In the legal world, does deliberate and intentional, does it have a different meaning to it, or is it the same shit? Just curious.
Suffering. Both counsel, I believe, stated that it has to be an intent to commit emotional distress. That's not what it says. Deliberate or reckless infliction of mental suffering. Or
maybe deliberate has more of a specificity to it.
Outrageous conduct. The conduct caused severe emotional distress, and the distress was severe. On the element of deliberate or reckless infliction of mental suffering, liability for outrageous conduct, this is under the restatement, liability for outrageous conduct arises when the wrongdoer desires to inflict severe emotional distress, when that's the intentional part, or when the wrongdoer knows severe emotional distress is certain or substantially certain to result from his conduct, that's two, or the third way is when the wrongdoer acts recklessly in deliberate disregard of the high degree of probability that emotional distress will follow. The reasonable inference from the allegations raised in the complaint is that the Laundries knew, and Mr. Bertolino knew, that Gabby was deceased. They knew the location of her body. They relayed that information to Mr. Bertolino. All the defendants knew that Joe Petito and Nicole Schmidt were desperately searching for their daughter at the time that the September 14, 2021 statement was issued. And I would submit that the allegations are sufficient to support an inference that the defendants knew that the statement was going to inflict emotional distress on the parents, or they knew or were substantially certain that it would, or at the very least they acted recklessly in deliberate disregard of a high probability that that statement would cause emotional distress to the Petito family.
Returning home in the van. It's not yours, it's us. He's got nieces, nephews who called Gabby Theron. Per the older sister's comment on the news, she had, per the older sister's comment on the news, okay, she had no contact with the parents afterwards. Yeah, I feel like Brian was her favorite and the sister knew it. Not really.
On the issue of outrageous conduct, I agree with what counsel had said. It's required to be so outrageous in character and so extreme in degree as to go beyond all bounds of decency. It requires an objective evaluation of the claimed misconduct to determine whether it is atrocious and utterly intolerable in a
I feel
civilized
like you're saying the same thing for billion.
community. And the burden does fall on the court. It's a question of law initially, not a question of fact. And generally, it is found where the recitation of the facts to the average member of the community would arouse his resentment against the actor and lead him to exclaim outrageous. The restatement provides a non-exclusive list of examples of what outrageous conduct is. Comment C in particular says, the law is still in a state of development. The ultimate limits of the tort are not yet determined. The caveat is intended to leave fully open the possibility of further development of the law and recognition of other situations in which liability may be imposed. It's instructive to look at the cases that I've cited in my brief where there has been conduct that's found to be outrageous and where it's been found not to be outrageous. In the cases where it was found not to be outrageous, in Williams versus Worldwide Flight Services, a former employee claimed that managers and some of his other supervisors had called him racial names, created a false record of disciplinary actions against him in order to terminate him. They did not allow him to work with other African Americans. They put him out in extreme heat and cold to load and unload planes, threatened him with job termination, accused of him stealing, and had him move dangerous and heavy equipment and cargo, and work extra flights so that he couldn't take his breaks. The court found that while the conduct was reprehensible, objectionable, and offensive, it did not rise to the level of outrageous behavior. In LeGrand versus Emmanuel, when 250 people were sitting in a church service, someone accused the minister of stealing money from the church to purchase a car. They called him Satan. They called him Macout, I think it's how it's pronounced, which is a name for the oppressive secret police from Haitian dictator Duvalier's regime.
Wait, what? Oh my God, that's really specific.
And they stated that his name means Satan. The court found
Is this in Haiti or something? Or are we stating cases that happen in the U.S.?
that although they recognize branding a thief as being certainly unsettling, embarrassing, and or humiliating, it doesn't rise to the level of being outrageous. And finally, in Duval Hotel Management, bride and groom had reserved a room for their wedding reception. The day of the reception, the manager of the hotel told them the room wasn't available, and so they'd have to have their reception in the lobby of the hotel.
Oh my God, no.
There was not enough room for the 190 people, and during the reception, there were other guests walking through the wedding party. Some of them attended the party, and some of them were walking through in swim trunks. The court said the bait and switch pulled by the hotel was not sufficiently outrageous to support a claim for intentional infliction of emotional distress. Now I'll move on to the cases where the court has found.
Jesus, that's crazy. I hope the hotel refunded them some of their money back.
There was grounds for outrageous conduct and a claim for intentional infliction of emotional distress. In McAlpin versus Sokolay, a woman went to a hospital because she had a throat condition. She was disrobed, she had on a robe, and she was sitting in the x-ray room when a doctor came in, unannounced, in the presence of other staff, berated her for not paying another doctor's bill. He said he was going to call security and have her thrown out. She fled the room. She couldn't defend herself because of her throat condition. She fled the room, and the court found under those circumstances that there was reckless and outrageous conduct.
This is what dictionary says. Deliberate is applied to what is done, not hastily, but with full realization of what one is doing. A deliberate attempt to evade justice. Example, intentional is applied to what is definitely intended or done on purpose. Huh? Deliberate is applied to what is done, not hastily, but full realization of what they're doing, okay? Intentional is applied to what is definitely intended or done on purpose. I need a better definition.
In Nims versus Harrison, a teacher alleged that 2 of her students had written some sort of publication in which they used inappropriate, extremely offensive language about her. They threatened to kill her. They threatened to rape her and her children and her cousins.
How old are these kids?
The court found on those grounds that's outrageous conduct.
Jesus.
In Ford Motor Credit Company versus Sheehan, a collector on behalf of Ford Motor Company had been unable to find the debtor who was behind on payment for his car. The collector contacted the debtor's mother, claimed that she worked at a hospital, and that 2 of the debtor's children had been involved in a car accident, and she needed to get in touch with him, so the mother provided contact information.
Oh my God, this debtor would sound like a great scammer. Holy shit. Oh my God.
In the interim, the son contacted the mother. The mother told the son about the phone call she'd received. He spent 7 hours contacting hospitals and police departments to find out where his children.
I'm sorry, the debt collector is that the same fucking thing? Debtor. The debt collector, sorry.
Were, only to find out that it was false. The court found in that instance that was outrageous conduct. In Dependable Life Insurance Company of Harris, the insurance company
I want to know, how old were those kids?
was required to make car payments to a bank if the debtor became totally disabled, which he did. He made his application. The payments were made initially, but then they stopped. The claims manager on 2 occasions contacted the debtor, called him a fraud, and attempted to frighten him from collecting under the policy. His car was ultimately repossessed. He went into bankruptcy, and he suffered emotional distress. The court found that was sufficient to make a claim for outrageous behavior and intentional infliction of emotional distress. In Liberty Mutual Insurance Company versus Stedman, the insurer, and this was mentioned by, I believe, Mr. Luca, the insured alleged that the insurance company delayed authorizing a double lung transplant, even though they'd been ordered to provide it, because they learned from the decedent's doctor that she didn't have long to live, and if they waited this out, in their mind, if they waited out, she'd die, and they'd not have to pay the cost for the lung transplant. The court found, and I think it's instructive in this case, the appellate court found that viewed in isolation, the conduct the insured had alleged with respect to the lung transplant is not so outrageous that it qualifies as atrocious and utterly intolerable in a civilized community. That's the position the defendants are taking in this case. The statement itself may be benign, taken in isolation.
Yep.
But the court considered. However, paired with her specific allegation that the insurance company knew, based on testimony from the insured physicians, that she had a very limited life expectancy, and further considering that the insured was well aware that the clock was ticking and that the additional emotional distress caused by the delay could well hasten her demise, the court found the conduct fell within the ambit of comment F of the restatement. Comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly, I have trouble with that word as well, Mr. Luca, peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge where it would not be so if he did not know. That is our allegation in this case. The statement's benign. Put it in context. Look at what they knew at the time the statement was made. That's what makes it outrageous. In Williams versus Mineola, another case that was cited to by Mr. Luca, there was a drug overdose. The police officers took pictures of the decedent, went to a party, and then circulated and made jokes about it.
Why?
In determining whether...
What kind of psychopaths are doing that? What? I don't understand why. Unless they knew the person, they fucking hated the person? Or is it just like a random ass person?
And I will point out, by the way, in that case, the conduct was not directed at the party who was filing the lawsuit. This was something that was done at the party and was discovered later on. In determining whether the conduct of the officers was outrageous, the court stated, as for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida, show a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to family feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it is entered, behavior which in other circumstances might be merely insulting.
Wait, sorry, I'm interrupting really quick. Okay, got a Quora answer right here. All right, got 40 years in editorial and publishing. They went to law school. All right, let's do this. Intentional simply means something done on purpose. So doing it knowingly, all right, that's intentional. Intentional tends to have little or no complexion of advanced thought or planning. All right, deliberate means intentional with the complexion of having carefully thought out in advance. Okay, so deliberate probably just means like more calculated. Intentional just means you did it on purpose. But deliberate just takes intentional to the next level. Calculated. Right. Deliberate tends to carry the complexion in advance of thought or planning. Intentional tends to not have. A deliberate insult is one that is calculated to incense you and not merely to disrespect. Okay, guys, what did we learn today? Deliberate, intentional. All right. Deliberate is just it's a more it's a buff version of intentional.
Frivolous or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering physical trauma because of the loss of a loved one and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for a severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved. Finally, in the case of Thomas versus Hospital Board of Directors, the decedent died during hip surgery in a hospital. And the death resulted from the physician giving an overdose of a particular medication which caused cardiac arrest. The doctor and the staff inside the surgical suite decided that they were just going to simply say that she died as a result of the stress from the surgery.
How could a bunch of professionals in one room decide that and be okay with it? That's so fucking confusing. Are they like really tight with each other, like super close friends or something? Family?
And that was their report was issued, and an autopsy was not completed on the body for that reason. A week later, daughter of the decedent was burying her mother, and she, while doing so, received a phone call from the coroner saying she needed to immediately return the body back to the hospital so that a proper autopsy could be performed because he had learned of the real cause of death. The court found the decedent's daughter had sufficiently pled the elements of a cause of action for intentional emotional distress and said, as noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, the actor's conduct may become heartless, flagrant, and outrageous. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. Like the last two cases, the Thomas case and the Williams case, we're dealing with a person. We're dealing with someone who was deceased. And we're dealing with parents who were incredibly vulnerable because of the fact that their daughter was missing and they didn't know where she was. And I think this falls within those types of cases where, as was noted, I think in the Williams case, special deference is paid by courts to family feelings where the rights of dead bodies are concerned. Comment F, which I already spoke to comment F. At the time the statements were made, according to the allegations of the complaint, which the court must accept as true, and which the court must draw all reasonable inferences from, the defendants were aware of the vulnerability of Joseph Petito and of Nicole Schmidt to emotional distress because of the uncertainty of where Gabby was or if she.
Yeah, so that's what I was mentioning earlier. So at the stage that they're at right now, this is all pre-trial stuff, and they're doing like all these motions. At this point, the court has to assume that the allegations are true for this time being. Now, it's a different story, of course, when you go to trial, right?
Was even alive at the time the statements were made by Mr. Bertolino. The conduct of the defendants became heartless, flagrant, and outrageous when the statements were made in the face
Flagrant,
of such
like that
knowledge,
word.
where
Flagrant.
otherwise the statements would not have been so outrageous or heartless or flagrant. At this stage, it's not the
Flagrant.
plaintiff's burden
New
to prove
word.
the allegations of the complaint. The question is whether the allegations as pled are sufficient to make out a cause of action, and I would submit that they are. Comment E to the restatement also says, in support of the outrageousness requirement, an unequal position of the parties in a relationship, where one asserts power to affect the interest of the other, may supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Again, the defendants knew that Gabby was deceased. They knew where her body was, according to the allegations of the complaint. They knew that the Petito family was desperate and upset. And had they just kept quiet, we wouldn't be here. If they had kept that knowledge to themselves, we wouldn't be here. We wouldn't be standing before you having this argument. But they didn't just keep quiet. Instead, with that unequal position in which they stood vis-a-vis the Petito family, they made that statement of hope. And they knew, or they should have known, that that would affect Joe Petito and Nicole Schmidt and cause emotional distress. Defendants suggest somehow that looking at the full statement from September 14 of 2021 will make a difference in the court's determination of whether or not there's outrageous conduct. The first paragraph and the third paragraph simply say it's a difficult time for both parties and the Laundries are going to keep quiet. That does not in any way soften the blow of the content of the second paragraph. I'm frankly surprised that both defendants have suggested that the term reunited is subject to interpretation.
What, did the other lawyer make that argument too? I thought it was just the laundry lawyer.
They suggest it could mean the person is not alive, and they cited two various articles in which remains were reunited with the family.
Please call them out on this.
But the statement doesn't say, we hope the remains of Gabby Petito are reunited with her family. It says, we hope the search for Miss Petito, not her remains or her body, is successful and that Miss Petito, not her remains and body, are reunited with her family. Frankly, I think the defendant should be embarrassed for raising such a ludicrous interpretation of their own words. And by the way, if those words are subject to various interpretations, that's left to the jury to decide what it means based on credibility determinations. We believe the allegations clearly satisfy the requirement of setting forth a factual basis for outrageous conduct. And I cited the court to the Williams case where it said if differing inferences can reasonably be derived from the facts alleged, the question of outrageousness is for a jury. I'll move on to the suggestion that Mr. Bertolino's statements are protected. I would agree, as they said, that a statement made by the defendants, although extreme and outrageous, may be privileged under certain circumstances, but there are no such circumstances in this instance. As the court pointed out, the ABA model rule of professional conduct is not binding on any, don't even know if it applies. It's a model rule. But suppose it is something that we should consider. It says an attorney may, doesn't say shall, doesn't say must, an attorney may make a statement to protect the client from adverse publicity, and in making that argument, the defendants go outside the four corners of the complaint. They suggest that Brian Laundrie and Roberta Laundrie and Christopher Laundrie received a great deal of publicity, that statements were being made about them, and that Attorney Bertolino had a right and duty to protect his clients from prejudicial effect of that publicity. Well, that's not what the ABA standard says. It doesn't say he has a right and duty. But none of this is referenced. This publicity is nowhere within the four corners of the complaint. And more importantly, looking at that statement, if that's what Mr. Bertolino's intention was at the time he issued that statement, how does a statement expressing hope that Gabby Petito is reunited with her family, how does that protect his client? If he wanted to protect his client, he should have disclosed where Gabby was. Ooh. Even if he had a right under those circumstances to make that statement on behalf of his clients, it didn't give him carte blanche to cause emotional distress, nor does it give him immunity from liability for issuing the statements. It simply says he can make them. It doesn't say under all circumstances he has that right.
All right, Bertolino, take notes. Take notes from this lawyer.
As far as the litigation privilege, it does exist in Florida too.
Bertolino's okay. Next time I should do this. I should do that. Oh, what else you got? What else did you say, lawyer? Okay, Robert De Niro. Let's go.
Degree. It allows litigants
Daddy
and counsel
De
to
Niro.
zealously advocate positions
Hi,
in
Misha.
court. Defendants suggest, again, going outside the four corners of the complaint, that statements were made. At the time the statements were made, there was intense law enforcement and media investigation. I'm not sure how you find that in the complaint, but they say the only reasonable inference to be drawn is that the Laundries faced a criminal investigation and media inquiries. Well, I don't know that there is any law that says reasonable inferences must be drawn in favor of the defendant. It says in favor of the plaintiff. They state that based upon the fact that there was a potential criminal investigation, Mr. Laundrie.
Man, Bertolino ain't gonna. Does he have any clients still? Jesus, I don't know who would hire him after this. Oh, man.
Laundrie has a litigation privilege. Mr. Bertolino has a litigation privilege to make that statement. It's not reasonable to suggest or to infer that the Laundries were the subject of an investigation, although it would be with regard to Brian Laundrie, unless Christopher Laundrie and Roberta Laundrie committed a crime that we're unaware of. The Arco case that was
Bertolino.
cited and referenced by Attorney Luca,
You ready?
when it talks about the absolute privilege, says, the absolute privilege, the Florida Supreme Court has explained, is part of a trade-off. The absolute privilege was created to encourage zealous representation and the free and full discovery of facts between the parties and the court. This absolute immunity resulted from the balancing of two competing interests: the right of the individual to enjoy a reputation unimpaired by defamatory attacks versus the right of the public interest to a free and full disclosure of facts in the conduct of judicial proceedings. The question here is, what was the judicial proceeding? What proceeding was going on? What proceeding was anticipated at the time that he made these statements? We don't know. There isn't one. And the statement has to be made in context of those proceedings, and that's the Ball versus D. Lights Enterprises, which I cited in my response. If they're suggesting the statement was made in reference to this particular litigation, it wasn't even contemplated at that point in time. Absolute immunity does not apply or include a publication of a defamatory matter. This is the Ball D. Lights case. Does not apply to or include publication of defamatory matter before the commencement, or after the termination of the judicial proceeding, unless such publication is an act incidental to the proper initiation thereof, or given legal effect thereto. Nor does it apply to include any publication of defamatory matter to any person other than those to whom, or in any place other than which, such publication is required or authorized by law to be made for the proper conduct of judicial proceedings. Again, what judicial proceedings were undergoing at that point in time. The statements must be made, according to the Arco Plumbing case, which I cited in my motion, the statements must be made to the court, to parties, to law enforcement, or witnesses. Arco Plumbing, that's the Arco Plumbing case. In this instance, the statement was made to the press, directed to Joseph Petito, Nicole Schmidt, and the entire Petito family. That's admitted by Mr. Bertolino in his motion to dismiss. In Buckley versus Fitzsimmons, which I also cited in my response, the court held statements at a press conference do not have any functional tie to a judicial proceeding. They also suggest they might have a qualified privilege, but that's only available when statements are made to police during a criminal investigation, and that was set forth in the Delmonico case. Mr. Bertolino cites to the Orange Lace Country Club case, but the court stated that statements necessarily preliminary to judicial proceedings include pre-suit communications required by statute or by contract as a condition to suit. There is no contractual or statutory obligation which would apply here. Defendants have suggested that there's an issue with causation, and they suggest that perhaps there's no discussion of causation in the complaint, but paragraph 40 of the complaint clearly says the emotional distress was caused by the statements made by Mr. Bertolino. They also suggest that the statements must be the sole cause of the emotional distress, and they cited the court to the standard jury instruction in civil cases 410.6, but they only told you about subsection A, not subsection B, which says, defines a concurring cause, and this is in the instruction for intentional infliction of emotional distress. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. It may be a cause even though it operates in combination with the act of another, if the extreme and outrageous conduct contributes substantially to producing such emotional distress. That's what we have in this case. In this instance, we have a family undergoing distress, wanting to know where their daughter was. She hasn't contacted them in a long time. And along comes this statement made by Mr. Bertolino, and the statement we would submit is a concurring cause of the emotional distress. Restatement, comment J to the restatement says, severe distress must be proved, but in many cases the extreme and outrageous character of the defendant's conduct is in itself important evidence that the distress existed. The allegations of the complaint show the conduct itself the nature of the conduct itself fits within comment J because it's so extreme and outrageous. Knowing someone has passed away, knowing a family is grieving to express false hope that she may still be alive is outrageous. Attorney Luca also discussed the issue of agency. It's an interesting argument in which the Laundries seek to distance themselves from Mr. Bertolino by suggesting that because the complaint alleges malice, he was acting alone and not on behalf of the Laundries.
Oh no! The Laundries were like, "Yeah, let's just throw Bertolino under the bus."
As Judge Carroll noted in his opinion, an attorney's acts are the acts of the principal, the client, and that's the Stinson versus Pravat case, where the court said the principal is liable if the wrongful act is done while the agent is acting within the scope of his apparent authority, even though the act was not authorized by or was forbidden by the employer, or was not necessary or appropriate to serve the interest of the employer, unless the act was done to accomplish his own purposes as distinct from the employer's business. That sounds more like an affirmative defense to be raised or an argument to be made at a later time that he wasn't acting on behalf, that Mr. Bertolino was not acting on behalf of the Laundries when he made that statement. But within the four corners of the complaint, there's nothing to support that argument. In fact, the statements themselves issued by Mr. Bertolino say we and our. In sum, I would submit to the court, I do want to address two other issues that were raised, I apologize. I believe I've addressed them. In sum, I would submit that, just as Judge Carroll found, the allegations of the Second Amendment complaint are sufficient to set forth a cause of action for intentional infliction of emotional distress, and both motions to dismiss filed by the defendants should be denied. Thank you.
Ms. Riley, I do have a question for you. If you look at, for paragraph 40
Of the complaint?
of the complaint, paragraph 40, subsection A and B, you began your argument indicating that this is not a silence case. This is about statements made.
And Judge, I'll agree to strike those two paragraphs. They shouldn't be there. I agree.
Okay.
We're not, this cause of action is not based upon their silence.
So then you will strike A and B, C, D.
Yes. I'm not going to take out the factual allegations earlier where that was said, because in my view, that shows a course of
That shows the context.
Right.
But I do recognize Mr. Metz's point in that because we don't have specific, to each of these counts, we don't have a specific title for the count. It would, the complaint is intended on making sure that we understand which statements we're actually talking about. And I also recognize in your complaint in paragraph 33, where it says, with regard to Mr. Bertolino, he released numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and Brian Laundrie to the national press and to the Florida and into Florida in particular, while Mr. Metz kind of breezed by that as far as a jurisdictional statement. Are these statements that you are also indicating could have caused?
No, that was purely for jurisdictional.
Okay, so therefore, the statements that we were talking about here are specifically the statement of hope that was done at, that we've talked about ad nauseum here.
Yes.
And then the prayer statement.
Yes.
And then that's it.
Yes.
Okay. All right. Thank you.
Thank you.
Wait, what? Did he just argue that his parents were his employers? That he worked for them while he killed Gabby? Wait, what? Where did you wait? Who? Where are you in the stream? Are you watching the live right now? Or are you in the beginning? Where are you at?
I am assuming you all know that I'm going to reserve on this particular issue before ruling. So that is what I'm going to do on the motions to dismiss. And I hope to have orders out for you all shortly with regard to those.
Okay, we'll wait
we do
for
have
it.
two other issues that we need to address. Oh,
I maybe had a rebuttal I could do in 1 minute. Could I just
1 minute?
Yes.
Yes, you can give me a rebuttal.
Timing you.
It's like the trial attorney that comes up for cross-examination says I have one more question.
Judge, I gave a closing once in 22 minutes for a 4.5-week trial, so I'm going to do this.
Okay.
Paragraph 40 doesn't talk about causation. So,
It's true. Yeah, cross-exam. I just got one more question. And they asked like 20 questions. I'm like, bruh.
Mr. Riley said it did. It doesn't, and causation is missing throughout.
All right, we're back to, this is Bertolino's lawyer.
Mr. Riley talked about recklessness. Count 3 and count 6 does not raise recklessness. It raises willfulness and maliciousness. There are 4 elements to intentional infliction of emotional distress. At best, Judge Carroll partially commented on one of them. You take those 4 elements as a checklist, and you read through this complaint, and you read through all of the counts. You're not going to check all 4 off. It doesn't set forth a cause of action for intentional infliction of emotional distress.
I have no idea what you're talking about. I'm so confused. The version of your stream, I'm so confused. Where are we?
It doesn't have all the elements, and that's within the 4 corners. And for this type of claim in particular, your role and what the courts have said are your responsibilities in the scope of what you can rule on clearly puts you as the gatekeeper for this, and there's not sufficient evidence for it to move beyond this point. Thank you.
That was 1 minute and 20 seconds.
I had a comment.
Mr. Lucan, did you have anything else you wanted to add?
Your Honor, I'm sure
I was like, oh, that felt kind of quick, but I forgot I have it sped up.
everybody would appreciate it if I didn't speak again. But I would just ask the court to
No, you again?
consider. I know Mr. Metz mentioned that counts 3 and 6 had the willfulness, maliciousness language as opposed to deliberate and reckless.
Okay.
It's the same for all the counts against all of the defendants. So to the extent that you're considering that argument, that applies. It wasn't just for the counts that applied to his client.
Okay.
Yes.
All
Okay,
right.
quick,
so
quick,
I'm
quick,
gonna be
quick.
reserving on that ruling. The rebuttal will maybe change my mind on that.
Yeah, who timed it? 1:20. Who's that petty person back there timing it?
I'm going to be reserving, and we've got our next issue.
But I'd be timing it too. Gotta keep them lawyers on their toes.
The easy one, which is the third request for production of documents where I asked for any account statements which showed transactions in excess of $10,000. Mr. Lupin has indicated that all those transactions were for payment to Mr. Bertolino, and that he was satisfied to have the court take a look at it and determine if he's correct, and I'm fine with that as well. If the court looks at it and says there's no withdrawals or transfers in excess of $10,000 that went to anyone, that didn't go to anyone other than Mr. Bertolino, then that satisfies my inquiry in that area.
Okay, and I looked at that earlier today.
And Judge, these motions don't involve me. Would you mind if I stepped out briefly and came back?
Absolutely.
Thank you.
He's like, I gotta use the bathroom.
I've got it right here in front of me. I'm gonna-
So if we look at these records, First of all,
Oh, now we are on the next subject, which is the Petitos. They want transactions more than 10K to be submitted. I guess what they want to see if the Laundrie family withdrew any money and then gave it to Brian in hopes that he'll, I don't know, maybe escape out of the U.S. and go to Mexico or wherever, right? That's what I'm assuming.
we're talking about transfers.
Why
I
they
know
would want
Mr.
the
Riley
money.
said that he wasn't interested in payments to Mr. Bertolino. There is a payment that's from Mr. Bertolino too. So let me.
Yeah, and that's kind of weird too. That there's a payment. So the lawyer made a payment to the family. So I wonder if the lawyer was like refunding some portion of the money or something, or you know, maybe it could just been like something as innocent as like maybe the Laundries overpaid and there was just like a, you know, maybe like a reimbursement or something. I'm just confused why there is a payment from Bertolino to the Laundrie family, but maybe something innocent.
If I could just explain the records to you, this might go a little more quickly.
Okay.
Quickly,
so
yes. Quickly.
If you look on, so one page of the bank statement is for a checking account and one page is for a savings account.
Mm-hmm.
So if you look on September 1st, there's a fairly large deposit.
Mm-hmm.
And that deposit corresponds from that check from the law firm. That's a law firm that's associated with Mr. Bertolino.
Mm-hmm.
So that's what that check is. Then that amount of money is transferred from the savings account to the checking account. And then about a week later, there's a check that's written to Mr. Bertolino. So
For far less.
for farmers, yes. But then the remainder of the money just stays in the checking account. And so, Your Honor, the payment that came in, the deposit, was for like a business transaction, totally unrelated to anything in this case. And you'll see that the check that was deposited is actually dated August 13th. So it would be outside of Mr. Riley's third request for production, outside.
Oh, okay. So Bertolino was already their family lawyer then. That's why Bertolino's involved. That's what I'm getting from this.
That date range, and also would have predated anything that would have happened between Brian and Gabby.
So I'm not interested in that. I know what that is, and I'm not interested.
Okay, so then the only other transaction would be
Ad
the
nauseum.
payment, the check to Mr. Bertolino about a week after that.
Okay. If you just give me 1 second, because I want to specifically look at the production request, and then I can affirmatively tell Mr. Riley that you have given him everything he needs or not.
So I haven't given him these records because again they don't meet with.
I know,
Oh.
but what if I'm going to look at his request, specifically look at his request, look at what you've given me, and then tell him he doesn't have to give them to you, or he does.
Okay.
Okay. And it's request number.
It's the third request for production. I believe it's the only request within that production.
So I think the judge is looking at the bank statements right now, and they're going to confirm.
Your request.
Okay, I'm satisfied.
Thank you.
Thank you.
So then, as far as the motion to compel, based on my in-camera review, I'm going to be denying the motion to compel. And Mr. Lippy, you could prepare the order for that?
Yes, thank you, Your Honor.
Wonderful.
Okay, so the judge double looked at it, so that means that there's no transactions more than 10K that they're gonna, turn over to the Petitos right now.
And Mr. Lippy, just to make sure that it doesn't end up out in the world, I'm going to give you the stack.
Okay, thank you, Your Honor.
I'm giving you your entire tab 5.
The FBI did open an investigation, but they ended the investigation January of like 2022, and then they like what's it called? They had like a little like blog post about it. So I say blog post, it sounds really casual, but whatever it is we want to call it for them.
One additional motion that we have to take care of.
Yes, Your Honor. The only remaining motion is the motion for protective order,
All right, next is
and
the
this relates
letter.
to the letter that was authored by Roberta Laundrie, which we discussed, I believe, at our last case management conference.
Yes, sir.
So this is just the motion that now brings it before the court.
Okay. And if you would like to, it's your motion
I mean, now that we just read the contents of the letter, I don't really care about this part anymore.
for protective order.
Do you guys read the letter yet?
Thank you, Your Honor. Your Honor, we filed an affidavit of Mrs. Laundrie explaining her authoring the letter and the purpose of the letter. Her affidavit explains that she wrote the letter to Brian and never intended for anyone else to see it. She wrote it prior to Brian
after
and
reading.
Gabby leaving for their trip. So it does not relate to any of the events that occurred thereafter. Her choice of words, in hindsight, are unfortunate, but that doesn't mean that the letter is relevant. Plaintiffs argue that
But see, here's the thing. We can't really rely on her words because she's saying like, oh, I wrote the letter before they went on their trip. It's like, but how can we believe that, right?
Mrs. Laundrie's affidavit is a self-serving statement of a party.
I think it's possible.
So the court should disregard it. Of course, the plaintiffs don't offer anything that contradicts Mrs. Laundrie's affidavit other than that argument.
We can't rely on her words
This was
for
a
it.
private note between a mother and a son. They would have been the only people to know the circumstances regarding its creation. Mrs. Laundrie is the only person who can comment on it at this point. Now, the letter is undated, although she wrote the letter because she and Brian were experiencing a difficult period in their relationship, and he was about to leave home. He was about to go on this long trip with Gabby.
I do want to know why. I mean, because I'm just being nosy over here, but why? What was going on with the relationship between Brian and the mom?
And she was hoping to repair their relationship before he left. Now, there are several contextual clues within the letter demonstrating that it was written before Brian's trip. And Your Honor, I did provide you with a copy of the letter, I believe. So first, Your Honor, the letter doesn't mention Gabby at all.
Judge, how can I respond to this if I don't see the letter?
Well, first of all, Your Honor, I would note that Mr. Riley has seen one.
I don't. That was well over a year ago, and I don't
He
have.
has a
Okay, so I understand.
Good point.
with
Good point.
contextual clues, it's hard to give context. I mean, with the last motion that we had,
Wait, the weird coincidence? Sorry, what weird coincidence are you talking about? Incest stuff? I didn't really get that vibe. No, not quite.
that's an easy thing for me to look at, and hopefully Mr. Riley to trust that I can read a bank statement and say, hey, there's none of these things that you're asking for in it. But you're asking me to make an interpretation, and that I think due process would permit him to be able to
Turn
argue that.
it
Understood, Your
over.
Honor, understood.
Turn it over.
So let me just bypass then referencing any of the content of the letter.
All right.
Great.
So going back, Your Honor, we have provided this affidavit from Mrs. Laundrie that explains the context in which she wrote the letter. And the plaintiffs certainly don't offer any evidence or any contrary affidavits that Mrs. Laundrie's affidavit is incorrect, or any other information regarding why the letter was authored, when it was authored, any of those details. They simply call it a self-serving attempt to withhold a key piece of evidence. And this leads me to my next point, Your Honor. This letter is not a key piece of evidence. It was a private note between the mother and son. The plaintiffs never saw it. The letter has not caused them any emotional distress.
How do you know that the letter didn't cause them emotional distress? I mean, if the Petitos interpret the letter, if they think the letter was written after the murder of Gabby, then yeah, that would probably cause them extreme emotional distress.
More specifically, the plaintiffs haven't demonstrated that the letter had any connection to Mr. Bertolino's statement, which is the foundation of their entire claim. Now, the plaintiffs cite to HEPCO Data, LLC versus HEPCO Medical, 301-7-406, it's a Florida 2nd DCA case from 2020, and also to Dees versus Kidney Group and Kiker versus Lopez. Those sites, again, are in their motion. For the argument that irrelevancy is not a proper ground for protective relief under Rule 1.280 Section C. Now, Your Honor, I believe that misreads the point that those cases were making, which is that for a protective order, there has to be something in addition to relevance as an objection. There must also be a showing of annoyance, embarrassment, oppression, undue burden, or expense. In other words, relevance is not enough. For example, the Dees case that the plaintiff cite said,
At this point, the Petitos have seen the letter. They have seen the letter. And so the Petitos, you know, if they thought that this letter was written after Gabby was murdered and then the mom wrote this to Brian, then I could see why it would cause emotional distress, right?
the protective order prevents any discovery concerning two prior clients and a new
Now, whether or not we believe Roberta that the letter was written before, right, that's to be disputed. For me, I could kind of see that the letter being written before. There's no reference to like Gabby or anything like that, and there's no date. So like Roberta's saying that like, oh, it was written before, and it was written because me and Brian were having issues, and this is kind of just my way of reaching out to him, mother to son, blah, 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 making all these references. Like I could totally believe that as well. I don't think it's like completely for sure an open and shut case where it's like Roberta definitely wrote this after Gabby was murdered. But if like I said, if the Petitos did believe that the letter was written after the murders, and I can see why they were distressed about it, but that's not what they're arguing here. Because the reason why I brought that up is because the lawyer was like, the letter didn't cause him distress, and the Petitos were like, what? How does he know? How does he know that?
venture formed by the other two members of the company, the information appears relevant to Dees' claim or reasonably calculated to lead to the discovery of admissible evidence. Again, so the Dees court considered relevancy. It was just that you needed to go that extra step about showing embarrassment or oppression, undue burden, or expense. And Your Honor, we've cited to a number of cases in our brief, which we provided to you, where courts preclude.
Wait, let me pause it really quick. Hold on. The weird coincidence, the letter, FBI had the letter. The transaction, they didn't bring up anything in the transaction right now. So is the transaction a known thing? Because they're not even talking about the transaction. The van being parked outside, Brian not letting them know where Gabby was at, the camp trip, the reservation change. Wait, I'm so confused. From 4 to 3 people? You're talking about when they went, wasn't the camping trip reserved way after? Like, I'm pretty sure when they reserved the camping thing, they knew Gabby wasn't going to be there. The fact that FBI confused Brian with his mom. Wait, what? Wait, where are you reading all this? Wait, what? I have no idea what you're talking about. I didn't read about any of this. Where is this on? The important thing about the letter is that if she did read it after, it supports the fact that she knew what he did, making their statement believe in false hope when they knew she was dead. Yeah, that's what they're alleging. I don't think it's strong enough. In my opinion, I don't think the letter shows that they know that Roberta knew that Gabby was for sure dead. But the letter does look really bad. But yeah, that's why they're gonna admit this into evidence. And then, if they do jury trial, they're gonna be the ones that decide that. Roberta's gonna go up there, she's gonna testify, she's gonna get cross-examined, and let's see, when she's up on the stand, let's see how credible she seems, right? No, I have no idea what you're talking about. I didn't read any of the stuff because the letter, the FBI did have the letter. Roberta said that she gave the FBI the letter before they made that statement. The transaction, well, they just said right here that there's no transaction that's going to be turned over to the Petitos, because the Petitos wanted any transaction more than 10K that went out of the Laundrie account, Laundrie, what the fuck their name is. I don't know about the Brian, not letting me know where Gabby was. I don't know what you're talking about. The van. Yeah. I'm confused.
Discovery on matters that were irrelevant or not reasonably calculated to lead to discovery of admissible evidence. Just to give one example, in Hoogland versus Dollar Land Corp, it's 330 Southern 2nd 509, 4th DCA 1976, the court held the appellate Hoogland was entitled to a protective order as to most of the material sought until such time as it may appear that discovery of those documents is relevant or that may reasonably lead to relevant evidence. So while not the only factor, relevance is a significant part of the court's consideration. The plaintiffs still have to comply with Rule 1.280B, which only permits discovery regarding matters that are relevant or reasonably calculated to lead to the discovery of admissible evidence.
Why do you believe that this letter would? You've seen it. Now I've seen it. Why do you believe that this would not be relevant?
Well, Your Honor,
Yeah, you got to let the jury decide that.
as Mrs. Laundrie's affidavit states, it was written.
Aside from statements made by your client, which arguably have a credibility factor that has to be addressed by a fact finder, what would be the reason that this would not be relevant?
Well, Your Honor, if I can't use the affidavit and I can't use the actual words of the letter, to describe why it wouldn't be relevant, I'm not frankly sure what to say, because those are the actual content of the letter and Mrs. Laundrie's.
But Corgi, the letter's expression is of over the moon affection is sus. Wait, were you talking about the incest thing? Was it? Are you the one who was talking about the incest thing? Sorry, what are you replying to? If you are replying about the incest thing, I didn't get any vibe of incest. I was like, yeah, this is a weird fucking letter. But sometimes parents write really weird letters to their kids. I don't know. I don't know what to tell you. If it was like, yeah, I don't know. We would need more background information to go from knowing not much about Roberta and Brian's relationship to seeing that letter and then jumping to incest. I think that's way too much assumptions that we're making. I think it's just like, oh, it's a weird letter. All right.
Affidavit are the reason why it's irrelevant, because she says she wrote it before Gabby and Brian went on the trip.
Okay.
My argument regarding the context of the letter was going to be that shows that it was written before they went on the trip.
Because this sounds like an argument that you make at trial when everybody has seen what you're trying to present, and then at that point in time we hire the witness, we make some credibility determinations, and then we decide whether or not it's relevant or not relevant. Rather than a protective order discovery stage where we're bringing in Mr. Riley here with his hands tied behind his back, not knowing how to argue it. I mean, essentially, when I took away the affidavit and the words of the letter away from you, I essentially put you in the exact same position that Mr. Riley is now in.
I understand, Your Honor. I mean, but certainly, he has the affidavit. He has the.
True, Judge. Okay, if the letter was as innocent as the mom says it is, then why does she care if people read it? Because the letter sounds bad. It sounds bad. It's the unfortunate timing. However, I think the letter was way too hyped, because once we read the letter and in its context, I was like, this letter doesn't look that bad. When I read the letter, it wasn't like, oh my God, dude, she definitely knew Gabby was dead. It was just like, okay, this is she's trying to pull the ride or die mom vibes thing. And the timing is just really unfortunate. So I'm not convinced yet whether or not the letter was written before or after the murder. I'm just going to keep waiting. It just looks bad, but I think the mom should have just released the whole thing, because, when people read the context of it, I didn't think it was that bad. It was just a weird fucking letter. But I can also see why she doesn't want it to be public, because she doesn't want that shit out there. It makes her look bad to a good amount of people. And it's a private thing that she wrote to her son. You don't want your shit out there. So I don't know. I could totally understand that. But I don't know. That's why I like this. I think this is why I like this case, because it's very interesting. It's a very fucking interesting case. I know morally where I lie between the Laundrie and the Petitos, right? Like morally, I'm like, yeah, the Laundrie, yeah, it's pretty fucked up, man. Damn, you knew that your son murdered or potentially murdered your future daughter-in-law. You didn't fucking care. It seems like you're kind of close with the other family. You blocked them. You didn't want to communicate with them. But at the same time, I'm like, I don't know. I need more convincing. Yeah, we'll have to see.
Ability to develop additional evidence through the course of discovery, take Mrs. Laundrie's deposition, stuff like that, where perhaps he could develop.
Ask her about a letter that he doesn't know.
I'm not suggesting that. I'm just saying that the only facts that we have at this point are the facts that we have.
I understand. We're very early.
Right. And Your Honor, the reason why this letter is particularly sensitive is even the plaintiffs acknowledge in paragraph 20 of their response.
Billy and Sons, there's one person that can testify to that. Their son, he is dead. Well, I think what's going to happen is I think the Petitos, they want to know, they want closure, right? And since Brian is gone, he's dead, there's going to be no criminal trial. I think they want closure. And because they were, seemingly sort of close to Brian's family, their kids were going to get married, they're going to be a family at some point, like one unit. And what happens is Brian comes back from this trip, Gabby's not there. They're like, where's Gabby? And instead of the family replying back and helping, they fucking just iced them out completely, not reply to them at all, fucking ignore them. So I can understand why the Petito family are like pissed off. They're like, what the fuck? Like, how could they fucking do this to us? They have a fucking kid too. How could they not sympathize for us, right? I can totally understand that. And I think even though anything that they do now is not going to bring Gabby back, Brian and Gabby, they're both dead. And people are like, well, what's the point of the civil lawsuit, blah, blah, blah. I think the family just wants to know what the fuck happened, what's up, and they want to know how much did the Laundrie family know. And I think by going through this entire lawsuit process, or go through discovery probably, right? And maybe through the discovery, maybe they'll find text messages. We don't know if it's going to be a thing or not yet, but maybe they'll find some text messages, maybe some emails, maybe some Facebook messengers where Brian was communicating with the family like, hey, Gabby died. I don't know what to do. I need help. And let's see how much the family actually knew, right? So I think that's why they're doing all this, because they just want to know what the fuck happened. So through discovery process, maybe they would have find out, whether or not Brian told the parents or told the lawyers. I just think it's going to be really tough because, in terms of what the lawyer knows, I think the lawyer is going to be covered by client attorney privileges. I have no idea how they're going to find out how the attorney knows. I don't know. Maybe there'll be some intercommunication within the family, where it says like, okay, Steve Bertolino knows that you killed Gabby. All right, now you're going to do this. And now you're going to, I don't know, maybe we're going to get some explicit emails like that. I think this is just a way of them getting closure and them just finding out what the fuck happened. And, they're probably pissed at the Laundrie and they're just like, yeah, we want justice for Gabby because there was never a criminal trial. And the person that did it, the cowardly thing, and killed himself. But yeah, I don't know. That's what I think this is going to be a very interesting trial because I'm just very, I don't know. It's kind of crazy. Okay. Hi, Kat. How are you doing today? You think incest in the family and she hated Gabby? How did you guys come to that conclusion? What are you guys reading? Or is it just like kind of like you're just like gut feeling type of thing? Especially since Brian had Gabby's van. Why do you have my kid's van and not her? Yeah, because Brian came back with Gabby's van and, what the fuck? Where's Gabby? Additionally, to find out that if you're Gabby's family, right? To find out that, let's say, Brian murdered Gabby, right? Sorry, not let's say, but Brian murdered Gabby. And he took her cell phone and was pretending that Gabby was still alive. Used her credit card, came back to the family. They all lawyered up. They didn't say anything to the family at all. They just stayed silent. And then they go on family vacation. Like all the, I don't know, just like being in the family's shoes, Gabby's family, like all of that is just really, it's just really fucking tough, man. That's tough to deal with. So I can get why they're pursuing this lawsuit, but I don't know. Do I think they're going to win? I'm not too sure. I don't know. I'm not too sure. I don't know if it's ever going to make it to a jury, but we'll see. Well, they could be subpoenaed, right? They can go through the discovery. They can go through to see what evidence might support the Petito family. So yeah, while like Roberta Laundrie can go up there and lie on stand, or the dad can go up there and lie on stand and be like, yeah, Brian never told us. But if they, subpoena the records, maybe some text messages, and it shows otherwise, then, maybe they can find some information that will support what the what the Petitos are saying. But I doubt they would email and show this information or text it. That's what I'm saying. I think it's going to be tough because I feel like everything would be over the phone call, right? It would just be like calling mom, be like, hey, blah, blah, blah. But you know what? We've seen a lot of stupid people before who document everything, who write search histories of like how to kill my stepson. I don't know, how to fake a hit and run or whatever the fuck it was. Like, we've seen a lot of dumb people immortalize a lot of the shit that like, having pictures, having search histories that are it's there. Can't get rid of it. It's there forever. Let's see. Dear Corgi and all my friends in Chatland, this testimony has been the most grueling mindful I have been through lately. Geronimo! There's no testimony going on. You're talking about the lawyers right now? See, what I don't get is why the FBI didn't keep the case open. Well, for the FBI, it's like, well, we know Gabby's dead, and the person who did it is also dead. So what's for them to keep open, right? I mean, what are they going to do? Investigate the family? And then, I don't think they believe the family was involved in the murders at all. They know the letter was written after Gabby disappeared. They didn't want to get into evidence because it's going to prove, they know the letter was written after Gabby disappeared. They don't want it into evidence because it's going to prove during the trial. I don't know. Did you read the letter yet, though? I don't think the letter is that bad. It sounds bad because there are some keywords in it that's like, ooh, that's kind of weird. Ooh, the timing is really bad. But I don't know. And overall, when I read the entire letter, I was like, it doesn't really prove that she knew that Gabby was dead. Latisha will forever be an example. Could they settle? Yeah. It's possible. Or it's possible that they'll get to, after they do their discovery and all that stuff, that at some point they could be like, hey, there's not enough evidence to go to trial. That's possible too, right? But we'll see what happens. This is all pre-trial shit right now. So this might not even make it. If anything, they are accessories after the fact. I don't know. I don't think so. I don't think they would be, right? Because would an accessory mean that I don't think so. I think they the son came home. I don't know. I actually I have to look up the accessory term, I guess, in its legal definition. Who's Roberta? Roberta is Brian's mom. But yeah, I mean, this case, I'm glad that I'm hearing a lot of different opinions about this case, because I don't think this case is an open and shut case. I think it's a tough one. But it's so interesting because, I've never heard of a case like this before. Like a family suing another family for a public statement, but then it's like, oh, they're accusing the family of knowing and the lawyer of knowing as well. Like, ooh.
That it is understandable that the Laundries would argue that the letter is embarrassing and most prejudicial to Roberta Laundrie. And our concern in this case...
Yeah, and I do wonder what qualifies as aiding and abetting, right? That is what I don't know. Because if anything, I was thinking back then maybe they would be charged with aiding and abetting their son, but it's not. But the son was just staying at the house, right? The son didn't leave anywhere yet. If the son maybe left to go to Mexico, maybe that would count as aiding and abetting. Maybe.
But that's not a. To be fair, that is not an argument for discovery. Not being required to turn over something in discovery. That is not.
Oh my God! Roberta hit him in the secret garden. You guys ever been to Busch Gardens before? When we were kids, we'd always make jokes about Busch Gardens. Busch Gardens being a euphemism for someone's bushy, a woman's bushy private parts. So when I read that comment, I was just thinking of Busch Gardens. Oh God. Okay, shut up. I don't think anyone's entertaining incest thing at all. I don't know. Maybe we'll find out more shit about the trial. Y'all just want there to be incest because it would be more juicier, huh?
Argument for a motion in limine.
Well, no, Your Honor, it is an argument for discovery because under the standard for a protective
where are
order,
we at?
if something is embarrassing, it can be protected. Okay, so in this situation, what we have is something that is embarrassing, and given the media attention on this case and how this letter could, would be put out into the public potentially, it's unfair.
Are there, and please correct me if I'm wrong on this or lead me in the right direction on it, but there is case law that suggests that the protective order does not necessarily prevent the other side from getting the discovery, but rather prevents the dissemination.
Well,
I mean, is there a middle ground here rather than, plaintiffs do whatever they want to with it, and you saying it never gets to see the light of day. Is there a middle ground here where we can proceed and actually give them some meaningful attempt to utilize it and determine whether or not it would be a relevant exhibit at trial?
There certainly could be, Your Honor. I mean, we could, if we
Any assistance they give him would be eligible for aiding and abetting crime, even if it was after the crime. I gotta look into that more. Brian crawling like Jodi Arias through the garden.
wanted to, we could work something out where we do enter into a protective order whereby Mr. Riley could see the letter and then.
Because that's not my understanding of what you're asking for in your protective order.
Right, that's right.
I'm asking. Order is like I want it to be shredded and gone and forever and ever.
Right. I'm asking for a Rule 1.280C protective order, meaning we don't have to disclose it, as opposed to a protective order where Mr. Riley and I agree to some terms as to the protection of it, like how it can be used, who can see it, things like that.
Okay.
Now that's something we could certainly work on. Although, Your Honor, I mean, I think I would be remiss without saying that. Regardless of, if you totally disregard Mrs. Laundrie's affidavit, totally disregard.
I'm not saying that I am.
No, I understand.
I'm asking you the question so that I can see the full crux of your argument.
Wait, Jodi Arias hiding in a bush, having a very creepy smile. You know the Homer Simpson meme where it's like him like hiding into the bush, but like replace that with Jodi Arias, but like with a creepy smile. And not because she's trying to hide, it's because she's trying to stalk you, okay, in the bushes. Oh my God, someone create that meme. We need one.
I understand. It's still, there is still a requirement that discovery is limited to those matters that are relevant to the litigation as framed by the parties' pleas. Okay? And so in this situation, the plaintiffs don't dispute that they've never seen the letter. They don't dispute that Mr. Bertolino's, I mean, other than maybe in his association with this case has seen the letter, but that he saw the letter at the time he issued the statement, or that it had any influence on his statement, or anything like that.
They have alleged, however, that the defendants knew.
Yeah, honestly, here's what I think. The letter sounded really bad, okay? They should have just released the full fucking letter afterwards and just be like, hey, this is the full letter. And then people would have been like, oh, maybe it's not that bad. I don't interpret it as that bad. Do you guys, when you guys read the full letter, you guys still think it's like really, really bad? I'm just like, it looks bad, but I don't know if it's that bad.
That Ms. Petito
Maybe I'm the odd one out on that.
And knew of the location in which her remains laid. And that factual allegation is one that they will have to prove in order to be successful at trial. Because without knowledge, then so while this statement may not have been the one to have caused the intentional infliction of emotional distress, it is the ramp up to that. It's the elements that it potentially could allow the elements of that to be proven. Does that make sense?
No, it does make sense, Your Honor. I mean, I can understand that perhaps, but again, I can't reference the contents of the letter, so I'm just trying to, I'm skirting a little bit to make sure that those words don't come out of my mouth.
Judge, I don't know if this would be helpful, but so it sounds like what we're really talking about is whether a confidentiality order should be in place. And in all fairness, I think we've probably asked certain things from the plaintiffs in terms of written.
This lawyer's trying to help out this lawyer. He's like, no, I just don't want the letter to be in. No. The guy's like, okay, maybe we should just do the confidentiality thing,
Discovery, where that may not be a bad idea. But of course, if you sort of start the discovery process without one, it's harder to get back in.
I agree.
So perhaps whatever ruling
The guy's like, no, it's not what I
the
wanted.
court makes, we at least would have some grace period to consider putting a confidentiality order in place, because that might help alleviate everyone's concerns for other issues moving forward as well.
He doesn't look happy.
That is an idea to consider. I want to hear.
He's not happy.
Mr. Luke, I have interrupted you a lot.
Oh, no, that's fine, Your Honor.
You are helping me out, so I appreciate that. I appreciate the indulgence.
Yes, of course,
Even though if it's annoying, I'm sorry. Mr. Riley, would you like to?
Yes, Your Honor.
Yeah, I felt like, because we heard about the letter. When did we hear about the letter? Was it like 6 months ago? Honestly, I'm going to be very honest. I forgot about the letter. I think the letter was brought up when I was live streaming. It was like the burn after reading letter. Something about a shovel and cake was brought up later on. I think I remember hearing about it, and I completely forgot about it until recently. I looked it up yesterday, and I was like, oh, this is new information. I was like, wait a second. Wait, I kind of vaguely remember this. Oh, I completely forgot all about it.
As the court well knows, we're not suggesting that the letter caused emotional distress to my clients. We're suggesting the letter, if determined to have been written after Gabby passed away, is proof that they were aware that Gabby passed away at the
Right.
time that the statement was made on September 12th.
Right.
That's the importance of the letter. As we all know, the letter references burying a body, bringing a shovel and burying a body, baking a cake and putting a shit in it. Those are criminal acts, by the way, that Roberta Laundrie has said she would commit. But those words are in that letter.
I don't think shit's in the letter, but.
Or then a saw or something, baking something in a cake.
Baking a file.
And by the way, her reference in her affidavit to these children's books
You're gonna bake a pedophile in that cake.
that has tried to explain why she wrote that letter to her son is ludicrous, because there's nothing about burying a body or bringing a shovel or putting something in a cake.
Oh, this is the books. The books. It's the books.
If somebody goes to prison, although Mama Bear did say she would bake Little Bear a cake on his birthday. This whole argument is based upon the affidavit of Mrs. Laundrie. Mrs. Laundrie is a party. Mrs. Laundrie has bias and
I wish a hottie would write me a burn after reading letter. You just gotta write yourself the letter then.
prejudice and a reason to say the
welcome.
things that she did in her affidavit. And if I were in her shoes and I had written that letter, I'd probably say the same things. But that subjects her to a credibility determination, and the court can't determine her credibility based upon that letter, and credibility is for the jury to determine. The cases that I cited regarding relevancy are all second. Two of them are second DCA cases. One is a fifth DCA. None of the cases that Mr. Lucas cited in support of his position with regard to relevancy are second DCA opinions. And also, it's their burden at this point to show good cause to protect them from annoyance, embarrassment, oppression, or undue burden or expense that justice requires. Well, I haven't heard from them what justice requires under this circumstance that would entitle them to a protective order. But the basis of their argument is relevancy. And again, Mrs. Laundrie has admitted she wrote the letter. The counsel's admitted that the letter is undated. It's up for a jury to determine, or up to a jury to determine when the letter was written. But I cited the court to the HEPCO case, which says relevancy is not a proper ground for protective relief under Rule 1.280C, and that's 301 Southern 3rd 406. It's a 2020 second DCA opinion. I cited the court to Dees versus Kidney Group, a 2009 second DCA case, which says it upheld the circuit court's finding that the information sought to be protected is not related to any pending claim, and the fact that it is not reasonably calculated to lead to the discovery of admissible evidence is not sufficient to issue a protective order. And I also cited the case of Kiker versus Lopez, a fifth DCA case from 1998, which held that holding that the argument that information is not relevant to the issues in the lawsuit does not satisfy the moving party's burden to show that producing the requested information would subject them to annoyance, embarrassment, oppression, or undue burden or expense. The simple fact that it might cause her embarrassment is in and of itself not sufficient to issue a protective order in this particular case. We're not talking about compromising pictures. We're not talking about financial information. We're talking about something penned in the handwriting of a party to this particular case. The cases, none of the cases that were cited by Mr. Luca support the suggestion that a protective order can be issued based.
Or you know what? Maybe I will slow it down when he talks. Well, actually, no, he sounds the best sped up because the way he talks is very clearly
On the affidavit of a party, not one of them. That basically what they're asking you to do is to make a credibility determination at this point, which will preclude me from moving forward with a certain piece of evidence, a critical piece of evidence in this particular case, to show what information the Laundries had at the time that Mr. Bertolino made the statement. So I don't see any grounds upon which they're entitled to a protective order in this instance.
Oh my God, stop talking about Roberta's bush, guys.
What argument would you have against a confidentiality?
Well, I have no reason to agree to a confidentiality agreement. I mean, that hampers me. Why would I agree to a confidentiality? So then if I'm asking her about it in a deposition, so now the deposition transcript is going to be confidential as well, or a portion of it? I mean, I don't.
This lawyer, he's like, first they didn't want to give me the letter, and now they want to do the confidentiality thing. Now, fuck that. I don't want any of that shit.
I don't see a reason why I need to be hamstrung.
Hamstrung.
We're not talking about financial information, which would be the appropriate subject of a confidentiality
What's
agreement. We're not talking about trade.
Hamstrung. What's hamstrung? What? Cripple a person or animal by cutting their hamstrings? What? Oh, severely restrict the efficiency or effective of. Hamstrung. Hamstrung.
Secrets. We're not talking about something that, if is disclosed, is going to give some party an advantage, an outside party an advantage in moving forward, such as if trade secrets were disclosed. That's not what we're talking about. We're talking about a letter in the handwriting of a party.
Your Honor, I think at this point, we probably wouldn't be in favor of a confidentiality agreement on this issue either, just because Mr. Riley just put probably the two worst parts of the letter on the record in open court.
Very true. But I think it was already in one of the court docs. The shit, it came out like 3 months ago, didn't it? The shovel, the shiv, the bird, the dead body. Yeah, it already sounded really bad.
So, I mean, and that's what we would be dealing with that throughout the litigation. I mean, he can.
Okay, so you just want me to rule then?
I think we just want you to rule.
Okay, very good.
All right. Yeah, good. I'll read the letter again for those of you guys that missed it earlier.
That made that decision easy.
Oh, thanks, Patty. I still got more to edit. Oh, God. Yeah, I got more to edit, but thanks. I get to relive my travels when I edit them. That's what I like. All right, can I just give you the spoiler alert? She rules and she says, yeah, the letter is in. And then you have to produce the letter to the Petito family. Boo hoo hoo. Okay, this is the letter here. Here you go. So this is the letter. This is the letter. This is the letter. Can I not read the quotations? I think she like quotes the Bible. Do I need to read it? I don't think so. Do I? Maybe just this part? I don't know. Okay. Here's a transcript of the letter. I just want you to remember, I will always love you. I know you will always love me. You're my boy. Nothing can make me stop loving you. Nothing will or could ever divide us, no matter what we do or where we go or what we say. We will always love each other. If you're in jail, I will bake a cake with a file in it. If you need to dispose of a body, I will show up with a shovel and garbage bags. I think it's so weird how some parents are like this with their kids though. So it's like, no matter what kind of fucked up shit your kid does, you're going to be there for them no matter what. Ugh. Blah, blah, blah. Okay. Sorry. I interrupted her. Sorry, Roberta. If you're in jail, I will bake a cake with a file in it. If you need to dispose of a body, I will show up with a shovel and garbage bags. Fly to the moon. I will be watching the skies for your re-entry. See, because like she writes this part right here. That's why I think that this letter wasn't written after the murder happened. It just seems like this is just like a whole thing where it's like, I love you no matter what type of thing. Right? I don't know. Because obviously he ain't going to be flying to the moon anytime soon. This man committed a crime. Anyways, if you say you hate my guts, I'll get new guts. Yeah, that's cringe. All right, here's the, I'll just read the whole thing. Romans 8:38, extended version. Remember that love is a verb, not a noun. It's not a thing, it's not words, it's action. Watch people's actions to know if they love you, not their words. Therefore, I am certain that neither death, nor life, nor angels, nor the ruling spirit, nor the things present, or things to come, nor powers from above, nor powers from below, nothing in the entire created world can separate our love. Neither hostile powers, nor messengers of heaven, nor monarchs of earth, nothing has the power to separate us. Nothing can separate us, not hatred, not hunger, not homelessness, not threats, not even sin, not the thinkable or the unthinkable can get between us. I don't know, man. They seem pretty separated now. Brian's dead. Not time, not miles and miles and miles. And I think that's all she writes, right? Yeah. And it's addressed to Brian Christopher Laundrie, burn after reading. And he doesn't burn it. I just want to know, where was this letter found? I think that would be another interesting thing to know as well. Did they find this letter on his body? I don't think so, right? I think they had this letter before his body was found. I think she said that she gave it to the FBI. Oh, can I look that up really quick? I think she said she gave it to the FBI. When did she give it to the FBI? Let's see. I think she gave it to the FBI. I'm going to pull up the affidavit really quick. She said the purpose of the letter was to reach out to Brian while he and I were experiencing a difficult period in our life. Brian had always been very communicative and open. But in the months prior to the relationship, it's been strained. They share a love of stories. Some language in the letter was using similar phrases to describe the depth of the mother's love. Now, she says the books that come to mind are Runaway Bunny and Little Bear, but it seems like the lawyer read the book was like, I don't see any reference to this. I'm confused. She explains the burn after reading. Sorry, I'm looking for... Oh, here it is. There's been some speculation that this letter was in Brian's possession or in his backpack when he died. That's what I thought. Insinuating that I gave it to him as he left my home on September 13, 2021. But that is not true because the FBI had the letter in their possession and questioned members of my family about it prior to October 2021. When my husband and I found Brian's remains in the reserve. Okay. So yeah, she said that she'd already given the letter to the FBI and it wasn't found on Brian's body or anything. So I kind of do believe Roberta's version of events. For now. Can I have a cake? I would literally kill and be featured on this channel for one. LOL. No cake for you. No wonder Brian was so entitled. He can do no wrong. Yeah, with a family or with a mom like that, shoot, if you're going to support your kid, make him a cake with a shiv in it, bring a shovel, some garbage bags. I don't know. Ugh. For me, it's like, I'm going to disown you. Bye. Also, remember Roberta went to pick up the Mustang in the reserves. The FBI didn't even know the car was in the reserves. Did she? I thought they found the Mustang parked out there. I forgot who found it. Yeah, I thought they found the Mustang parked right outside, and that's where they knew where to search. No? She knew she was dead, or she wouldn't have given the "I love you no matter what you do" line, and the burn taunt notice is the topper. Corky, do I still stream on Twitch? For some reason, I never get a notification. Why? You never get a notification? I think I stream on Twitch after I stream on YouTube usually. Join the Discord. You get notifications on there. I don't know. Twitch notifications are kind of weird. Sometimes they work, sometimes they don't. I think technically when you follow on Twitch, you should auto get the alerts, but I don't know. Sometimes you don't. But you can have Discord notifications on. I usually put the notifications on there too. But yeah, I still stream on Twitch. I play video games though, so it's a very different vibe than here. I play video games and we just chill. You know, we chill in here too. All right, guys. Anything else you guys want to talk about before we head out? Did I miss any? I think I missed a lot of messages. Ooh, dude. You guys were talking about Roberta's bush. Inappropriate. Some mothers need to chill out and not get so hung up on their son. The letters woe. Yeah, Patty Cat. I don't know, man. That ugh. I get weird vibes from that. But yeah, just weird vibes. Just an idea in my head, but the burn after reading thing could be an inside joke. That's what she's saying. She's saying it's an inside joke. She said that like it's something that like Gabby introduced, and it's like an inside joke between the three of them. And yeah. When you need hiding, I'll hide you in my bushes. It tells us a lot about how Brian ended up the way that he did. I wonder though, when Brian left the house, if the parents knew that he was going to go and take his life. Because I feel like if I was the parents, I would be keeping an eye on my kid, you know? Make sure he doesn't do anything stupid or any more stupid. Not Brian dying alone eating dirt when Roberta promised him cake. Mama. But yeah, I still stream on Twitch. Noah. Oh, God. Guys. Yo. I watched one of your Twitch streams at work one night, got caught up and had to explain it. Not as easy as it seems. I got caught. Where your coworker's like, what are you watching? Some stranger playing video games on the internet? What a great way to explain it. Hopefully I wasn't talking about anything weird. Sometimes, you know, the topics on there, a little bit weird. But I don't have to worry about censorship on on Twitch because, you know, on like YouTube, there's like the demonetization thing. Twitch, you don't have to worry about that. Zer must be their family tradition. God, guys. Okay. I think that's about it though. This was a long hearing. It was pretty long. It was like almost 4 hours long, I think. So that's why I sped it up to 1.5. So if it's too fast for you guys, I usually don't listen to things that fast. I usually adjust it depending on how fast the speaker is. But I just did a blanket 1.5 because I just wanted to listen to it again quickly. But if you guys are watching this in the VOD, I normally speak really fast anyway. So I think if you watch me in 0.75, it might be okay. And then, you know, you listen to me in 0.75 and then the video will be like 1.25. I don't know if that's how it works, but yeah, maybe it'd be listenable. Your manager. Just be like, hey, I'm just enjoying my life, okay? Yeah, tell your manager to watch my stream. There you go. Bye, everyone. This stream is awesome. Guys, thank you so much for hanging out. I am going to be heading out to Chicago this week. Let's see how that goes. Apparently, Chicago weather is really nice right now. And yeah, it'll be my first time. Well, actually, not my first time in Chicago because I have been in Chicago before when I was a kid. But I'm going to be in Chicago this weekend. I'm going to go to the airport today. But we actually fly out at 5 a.m. Oh my God. That means I have to get up at like 3 a.m. Bro, I'm going to be so tired. But guys, I appreciate the banter. You know, I know a lot of you guys, some have disagreements about, you know, what's going on right now. And that's cool. It's fine too. It's nice listening to different sides of perspectives and stuff like that. And you guys are all like cordial and chill about it usually. So it's cool. Guys, thank you so much for watching. I don't know if you have anything else coming up. I think the only thing I know coming up is like Coburger, gag order, hearing. That's coming up in the beginning of June. Is Sarah Boone still happening in July? I don't know. Maybe Sarah Boone in July. Chad Daybell next year, June 2023. And then this one has been pushed from August to June of 2023 as well. But oh God, DB. Is it for the restitution stuff? I don't really keep up with the DB stuff, but I did last year that there's supposed to be like a restitution hearing or something. Oh, no, I forgot. There's supposed to be sentencing, right? For Laundrie? That's right. Letitia's all done, but I think sentencing for Laundrie, Murdoch, I think they're appealing. We'll see how that goes. Yeah. Okay. Well, we have some stuff to keep an eye out on. Have a good Memorial. Oh, yeah, right. That's right. It's Memorial Day weekend. Yeah, you guys have a good 3-day weekend if you have a 3-day weekend. It's for the battery. Oh, that's right. Yeah. For, right. His previous girlfriend, right? Yeah. Jesus. That DB guy, he needs to, I hope he just rots in jail forever. Holy shit. People like that just need to be locked up. Lock him away. Lock him away. That guy's crazy. How old is DB anyways? He's 40? Oh my God. He's 40 years old. Jesus. 40? I'm gonna be honest. I thought he looked way younger. Like 50. I thought he looked, let me see his picture real quick. I thought he looked younger. Yo, dude, this picture of him looks so crazy. There's this mugshot where his eyes are all like crazy, like Jesus. Man. Okay, mentally. Dude, I couldn't have watched the entire trial. I would have been so fucking triggered. Oh, God. I watched clips and highlights of it, and that was already like, my mind just wanted to rebuild his fort. Oh yeah, I forgot. The dude was building like a fort out of boxes. You know, maybe that's where Letitia got her idea from. She was hiding from that box of tissue when she was in trial. Oh God. All right, guys. Well, thank you so much for hanging out. I hope you guys had an interesting time here. If you missed the stream earlier, we just had a really super chill stream, just watching the Petito v. Laundrie pretrial hearing stuff. And yeah, I just want to listen to it with you guys. I don't know what else is there. Oh yeah, join the Discord if you haven't already. Join the Discord. It's a community hangout area. Join it. I also stream on Twitch as well, but I play video games on there. If you want to stop by, feel free to say hi. We just chill on there. But this weekend I am going to be gone. We're going to go to Chicago, and I don't know. We're definitely not going to get Chicago pizza. Ugh. I did hear though Chicago pizza is different than deep dish. Is that true? I always thought deep dish was Chicago pizza. Chicago pizza versus deep dish. Is it the same thing? Chicago style slice is built upon a flaky, thin, deep crust, similar to a traditional pie. Ugh. On the other hand, Detroit style pizza relies on thick and fluffy crust reminiscent of focaccia. Okay, I don't know what I'm reading. I hate pizza anyways. Why am I reading this? I hate pizza. I hate pizza! All right, everyone. Have a good weekend. Take care. And I will see you guys all in the next one. All right. Have a good weekend. It is Thursday right now, but enjoy your Friday, Saturday, Sunday, and whatever other days that I don't see you guys. Wait, too much of a boomer. Oh gosh. I think the people that just post on the Discord just like to shit post sometimes, you know? But you'll be surprised. I think most of the people in there are probably like 30s. They're in their 30s. But 30s is considered boomer, right? All right. Bye everyone. Have a good one. Take care. And I will